number 1, we had filed an additional affidavit. The record may be called for. We have an extra copy.
But I find one regular first it started. There is charges if you are
Appeal is not this court. Appeal is some other.
Okay. With regard to item number 41, maybe please your lordship, with the consent of the other side, I beg to mention item number 41. Your lordship, due to certain health emergency, learned and this council has to leave for Bihar. Yet and his 102-year-old grandmother, who is in a serious condition. At the same time, his father-in-law is also admitted in the hospital due to prostate glands ailments.
Huh?
Due to prostate glands ailments, his father-in-law is also admitted in hospital. At the same time, his 102-year-old grandmother is also in a serious condition.
When do you want it?
May 1st week. May 1st week.
Item number 41. It has been informed by the counsel appearing on behalf of the respondent that lead counsel Mr. N. Alam had to go to Bihar on account of certain medical emergency. But the matter, the second week from me.
Right.
Okay, I need some accommodation, Lordship. I can remember to can it be a 2, Lordship? I have a matter in I can put number 1, Lordship. 4, I think. Yeah.
Item number
2, Lordship.
2.
Yeah. At 2, Lordship. I have a matter in 1.
May I please, your lordship? I for item number 20. With the
Item number?
20.
And you? 2. Then why are you mentioning it? Let him complete. Item number 2. You don't want to do it today?
No, I want to do it today, Lordship. I have a matter in court number 1, Lordship. If Lordship allows passover, then
Okay. What is the item in court number 1?
4.
Okay, it will be over. Don't worry. I'll be
Lordship,
dictating on.
he will do that. If
Hello.
not, problem.
With the consent of the other side, I'd like to mention item number 20 of the deleted.
Hmm.
May be taken up after the vacation.
20.
Yes,
Okay. Why the matter has come up for orders?
lordship, the service is complete.
Then, but you need it after 2 weeks. Service is complete. Let it go for hearing. Service is complete. The LCA has been received or not?
Yes.
Then, so you appear. Then nothing is going to happen. Over. Don't worry. What was your section 47 application?
Correct. That was objection to the content of the objection is like this matter. We have stated you have not calculated your equitable amount properly. You have to recalculate, and
That cannot be a 47
it
application.
was not a 47. I was personally present inside the court. But the court wanted to know it has to be a 47. So we had no other way but to write 47. It's an objection otherwise with the application. It's not a 47.
So it is actually not a 47. It
No,
is
no.
simply a case by which you have challenged the what is the amount.
Exactly.
That's it.
Sometimes when there is one issue I have to intimate from the court. So far as the intimation about the fire was given on 2nd day, 23rd.
Hmm.
And the claim form was submitted on 14/6/2002,
So from there only it will come.
just 1 month after that.
So you have calculated.
And they have filed affidavit saying that their claim, according to them, should be banknote and compounded.
No compound.
Yep.
Unless it is stated.
They have calculated like that.
Where is it?
Yes.
Why you are holding 18% interest? Kindly come to D, serial number D.
But this was because they freeze interest.
But then also the interest was only given from that amount only. How are you having 18% interest? That aspect has not been decided. The only thing is that they say that they are going to be entitled to interest at 2% above the bank rate.
Bank, yes.
So that will be 2% above the bank rate, which they are saying it will be 14% or whatever may be plus 2%, 16.
60%.
Then why you are making it 18% again? How many times? Because the basic idea,
Right.
as could be seen from the trial court judgment,
Right.
is very clear. They say that normally they are entitled to interest if it is not done within 30 days from the date on which the claim was made. So 30 days, because they get the chance only to do it within 30 days. So thereafter, they say that the interest which only finding which is there
Right.
by the trial court, as well as by the appellate court also, to the effect is that it is 2% above the bank rate. Then why are you putting it 18 again?
Either 30, if your lordship will have to decide, but then we calculate, because they are claiming one thing, we are saying something, they are saying something. Now,
No, you need not do anything. I have only asked you to do it so that I can only certify it. Nothing more than that. What is the amount due?
Right. now that but this date has come for the first time, man. The claim form we have obtained a copy from the record. It is 14/6/2002.
Hmm.
So there, copy, if your lordship says that it will be the lordship passes an order that it will be 1 month after that date, then the fresh calculation is to be made. Number one. And secondly, my lord,
What is this?
second issue is the principal amount. If your lordship says that they are not entitled to principal amount, then their calculation will not
Huh?
compound it. Sorry, compound interest.
Compound will look into it.
My
Don't
lord,
worry.
That
about
is
that.
one issue, and this is second issue, my lord. Then the rest of the issues are
Because unless it is said to be compound interest in the decree,
my lord.
the question cannot arise.
Exactly.
So that is, don't worry with that. But you have made the wrong calculation here again.
During the course of the day, we will verify.
Then when was your first payment made?
First payment was next page of payment.
Yeah.
6/9/2020. First payment of 15 lakhs.
So it will be therefore apportioned first against the principal, against the interest.
Interest.
Okay,
That we have
then,
done, my lord, always against the interest.
then
Then again interest.
33.
Yes.
33. Then again the next payment made.
Next third page. And 32,08,891 payment. And this 5 lakhs to lottery kindly in between 27 and
No, it
32.
will be actually 32 lakhs or something.
Yes, 32 lakhs.
So that will be 32 lakhs.
Yes.
So that has to be again set off from 62.
Yes.
So it comes to 30.
Now comes to 30,74,000.
Then the next payment of 5 lakhs made.
1811, again, my lord, serial number are this amount we have paid by way of a check, but they have not collected from the decreasing.
So that check has become useless.
No, but they cannot claim interest on that.
But that check is not, you should have deposited in the court.
We
No, no, in the court's account.
account
What is this check business? That is it's a piece of paper now.
is to be revalidated.
Did you revalidate thereafter?
No, they have not.
Then how does it make any sense? Either you have to deposit in the court's account. So there remains 32 lakhs on interest
Yes.
on here. So we can't take that 18 lakh, 18/11/2021.
All right.
So that remains there. And then interest again on the main principal again, which remains from now let's see how does the trial court look into it. How does it come to that? Kindly come to 152 page.
Page 1. Yes.
What is this 166? That is per log. The value of 1,66,000 is per log into 414.
Yes.
Why it is divided by 2850?
It's possibly because court may kindly come to this plate.
It's simple calculation, if you permit me, I will
Yes.
explain. The total cost of 2,850 logs were 1,66 lakhs. So 1,66 lakh was divided by 2,850 logs, then we get the cost of one log. And it is divided thereafter by 414 lakhs, so we get the,
Multiply.
So that is
Multiply.
24 lakh.
yes, so that is how the calculation is.
And what is this portion of here in the trial court judgment? It is put in italic at page 153.
Page
153.
Reference you get in the decree at page 67.
Hmm?
Reference of these calculations, your lordship will get at page 66, 67.
Page 66.
Yes. This is a decree. 66 is part of the judgment and order, and 69 is the decree. Relevant is at page 70.
Where is the application filed by them for
That your lordship.
execution?
Page 19.
Huh?
19.
19.
1. Page 23 is the schedule where they have made the calculation.
And where is your objection?
That your lordship will find it page 25.
Yes, Mr. Mishra, you have to say anything?
Yes.
Well, there are two parts of the decree. The first is, as we have claimed in the plain, interest at the rate of 18% from date of incident, that is 22/3/2001, till filing of the 18%. On 2,850 logs, it came to 59 lakhs, which was allowed. The appellate court was also, I placed it last occasion, appellate court was aware of the decree which was granted to us, which included the interest with effect from the date of incident till filing of the suit. At paragraph 32, page 103, I have placed it up. And yet, the appellate court did not interfere in the judgment of the Lord, nor it was challenged. My lord, if your lordship will kindly note down, there is the in paragraph 21 of the appellate court's judgment, whatever was their challenge, all grounds were reproduced in paragraph 21. Your lordship will find not a single place they have challenged this part. Schedule B, they have not challenged. So this is one part which, according to me, is concluded by the appellate court judge. Now, what the appellate court did, that it says that instead of 2,850 lakh log, the calculation shall be now, will be limited to 414 lakh. And therefore you compute. So the appellate court did not interfere, except to the extent that in place of 2,850 log, it would be now 414 log. We accordingly made calculation and then filed our execution petition. When the matter was, your lordship took up the matter on 3rd of April. And of course, those things are not reflected in the order. But if your lordship remember, two issues that your lordship of the view that I should satisfy your lordship. First was, adjustment was of 1 month interest from the date of incident because of IRDA Act. This is what your lordship asked us to do. And the second issue was compound interest, whether we will be eligible or whether there is anything in the decree which entitles us to recover compound interest in the calculation. So I'll address the first point. Your lordship will kindly see the date of incident is 22/3/2001. Now I must make one thing clear. My learned friend is disputing that we filed claim on so and so date and then incident to inform the next date. Your lordship will kindly come to the appellate judgment at page 72. It starts, and the relevant your lordship will find at page 83. Their own case. Their own case, paragraph 16, I'm placing before lordship. The defendant have further denied the statement made by the plaintiff that the fire broke out in the mill premises at about 1:30 hours on 22/3/2001, in which all logs lying in the open, excepting one log, were completely destroyed. In this context, the defendant, your lordship kindly mark it, defendant had stated that the preliminary inquiry was made by Sri N. Katoki, surveyor and loss assessor, engaged by the defendants on 22/3/2001, same day. Because immediately we informed, that moment we informed. So there is a finding, there is their own statement made before the appellate court, which has been recorded. It has found the basis of inquiry, so and so, and all these. I'm concerned only with the date.
This will be apparent, I think, whatever the learned judge has quoted.
Yeah.
Must be there in their written statement.
Yeah.
In
So-
their written statement, they may have stated as to when they have appointed the date.
Yes, it's on the same day. This is a submission recorded, I think that,
No, as per 9/6.
yes. 9/6, my lord, I'll have that.
No,
I
only
know,
thing,
because that
I'm
is the
only
basis on
asking-
which your lordship has
No,
directed us.
understood. I understand.
Yes.
But only thing, as per 9/6, what is the time within which the claim proceedings has to
Your
be?
lordship will have to first 9/2, your lordship will see, the time is 30 days.
Where is the 9?
We have given you copy. Extra copy we have. if
It
your
is there
lordship-
in the document.
Yes, yes.
Yeah.
Eh,
You also annex.
It's here, we have given, or now also we are giving.
Yeah, I think it is.
IRDA, my lord.
Yes, 9/6.
9/2. Where the insured is unable to furnish all the particulars required by the surveyor, or where the surveyor does not receive full cooperation of the insured, the insurer of the survey, as the case may be, shall inform in writing the insured about delay that may result in assessment of claim. The surveyor shall be subjected to the code of conduct laid down by the authority while assessing the loss, and shall communicate his finding to insurer within 30 days from the date of his appointment, with a copy report being furnished to insured if he so desired. Where in special circumstances, either due to special complicated nature, the surveyor shall, under the intimation to the insured, seek an extension, those extension not done. So the time limit is here. And then consequence is there in 6. But what I would. Okay.
You see number 5.
Yes.
On receipt of the survey report or the petitioner's survey report, as the case may be, an insurer shall, within a period of, offer a settlement of the claim to the insured. 9/5.
Yes. Yes.
But this will happen after a long period.
My lord.
This will happen after a long period because you see, if you see 9/1,
Yes.
he has to intimate immediately,
Just
and immediately thereupon it shall be done within 72 hours of the date of receipt, which
Yes.
means it is within 3 days they can have another.
yes.
Then the surveyor shall be subject to the IMAN and shall submit a finding within 30 days from his date of his appointment.
Yes.
So just for example, if it
Yes.
is on 22/3 you have intimated,
Yes.
so he has come on 22/3, he has to give on 22/4.
But he has already given on 22/3 itself, paragraph 16.
No, it's okay, but he has to give by 22/4. Then, if the insurer on receipt finds it is incomplete in respect, he may again intervene, and such a request may be made by the insurer within 15 days from the year. So 15 days here, another 15 days. The surveyor on receipt of the complaint shall furnish additional report. On receipt of the survey report, as the insurer is within a period shall offer the settlement. For any reason in writing and the year decides to reject the claim, it shall do so within 30 days from the date of receipt of the surveyor's report. So, either by within 30 days, they can reject it from the surveyor's report. So, before 22/5/2001, they are to reject it or some additional report, whichever may be. Upon acceptance of an offer from settlement, as stated in clause regulation here by the insured, the payment of the amount due shall be made within 7 days from the date of acceptance of the heir by the insured. So when you make that offer, in case of any delay, the insurer shall be liable to pay interest at the rate of 2% above the bank rate prevalent at the beginning of the financial year in which the claim is being reviewed.
Yes.
The bank rate. So here the court uses the word 2% above the prime lending rate.
That's in respect of pendentalite interest and future interest, with effect from 13/3. Because if your lordship sees the date, it happened in 2001. Kindly see IRDA when it came into force. Came into force. It came into
2002.
force on 26/4/2002. Will not have retrospective effect. That is why that day your lordship has noticed,
Hmm.
while dealing with issue number 12 at page 57. Yes, yes. 64. Your lordship has seen 64. Kindly see 64, page 64.
IRDA came in 99.
But this
This came in 2000.
2006.
You're
2002.
referring to page 64.
This the other day I praised.
Yeah.
And your lordship has last but one line, one paragraph. However, the plaintiff is entitled to interest 2% above the prime lending rate at scheduled bank rate as on so and so date. And your lordship's comment was that whether IRDA or not, the court says, however, if the word your lordship lay emphasis on the word however, on third,
So it makes it very clear.
makes it
It's
very
the prime
clear.
lending rate. Whatever they use later on,
Yes.
that is immaterial.
Yes.
But this is the finding
Yes,
of the issue.
yes.
Now, that is one thing. But how does the court take into account the interest prior to? Just merely giving it would not do. But how does the court take into
Your lordship kindly have the plain. You have given your lordship the plain. We have extra copy. We'll give your lordship the plain.
Yeah.
Your lordship will see the schedule. The last page.
Ah.
Last page. Lordship got my lord. Schedule.
this one?
No.
The affidavit
There's written, there's plain, my lord, our plain. The plain is there.
of plain.
Type copy, Jana. I made a mistake. I should
The
have made
plaint I
a
remember.
compilation.
Plaint I remember that.
So your lordship will kindly see. I'll just refresh, my lord.
No, I understand, but where has the court dealt with that aspect of the matter? This is interest, because I'm saying, why the court have gone into 9(6) and say they are to settle within 30 days.
So far as 9(6) is concerned,
Hmm.
18% has got nothing to do with IRDA. That's the one that we claim, because IRDA was not in force that moment when the incident took place.
Then
And-
can't we come to an opinion that the court did not look into when you ask for a relief as regards 18% that the
Yes.
court does not give you?
Yeah, it's there. It's mentioned.
Ah.
The lordship will see at
Yet कागज किसमें दिख yeah, report document.
my lord will kindly come to paragraph 23.
Of?
Plain.
Yet
Plain,
plain
no,
to
no,
कागज
plain.
पण this will go to.
You take out the
So we are
yes.
every time we are. Right. Give me additional copy. See, normally I
Yes.
keep it as marked it, but here as I have not marked it,
Yeah.
they have
This
kept
we are
it
giving
somewhere.
a lordship a type copy. Common formalization.
Ah. And where is the written statement? You have a copy of the written statement?
We have given your lordship last time both written statement and as well as the plain.
All these things they don't.
Then you do. I had placed, my lord, even the reply at paragraph 33 of the written statement, if your lordship remember.
I understand, but these are not here. If it is not filed, we'll do one thing, we'll adjourn this matter to be listed after here. File all these documents by way, or we call for the records of the trial court. These are not available.
Let the record, now since he's going after view, let the record come.
Huh?
Let the record come. Better.
We stay there in the meantime. That's it.
My lord, I will
Hey.
kindly hear me on that.
No, I'm staying it.
Without
I'll stay
hearing,
that. Let it stay there and
my
let
lord,
it come up after view.
my lord, may I just submit, my lord?
Hmm.
Your
No, they
lordship
say that they are
your
liable to
lordship
pay
is
some amount.
sitting while deciding an appeal by the executing court.
Hmm.
And therefore, your lordship's jurisdiction, with all great respect, will not be more than what the jurisdiction and appellate court has, executing court has.
Yes.
And this is decided, there's recent judgment, my lord, 2023,
Hmm.
and also to 2017.
Hmm.
So your lordship will hear on that, because they have not challenged these before the appellate court. And your lordship cannot, my lord, with all respect, cannot sit over the judgment passed by the appellate court and affirmed by the trial court and affirmed by the appellate court. With all great respect, my lord.
Mr. Mishra, I'm not sitting over those judgments. I'm not sitting over nothing. I'm not. Here I am exercising the powers on the 115 as to whether the trial court was justified in doing, the executing court was justified.
They have,
I think I have that jurisdiction.
my lord, with all respect.
I may
If
not
your
have a
lordship-
jurisdiction to touch on the decree.
Yes.
I may not have the jurisdiction to touch on the first appellate decree. I don't have. There is no quarrel with that proposition. But the fact that am I entitled to or have the jurisdiction exercising the powers under 115 over the executing court, I think I have.
No,
Now, the
therefore, your
fact
lordship,
is as to whether this has been done rightly or wrongly,
in accordance
is-
with the judgment.
according to the judgment,
Agree.
we
Yes.
will consider it. Now, in the meantime, if this 4 crores and all is being done, it will have any effect. Now, they say that there is a particular amount, they say 55 lakhs. Let them pay it to that. Stay subject to this 55 lakhs.
60 lakhs.
I wish your lordship will have decided. I will, this is great.
60 lakhs. 60 lakhs. It comes to 60 lakhs.
That will be without prejudice to the
Hmm.
claim that we have.
No, without
Whatever.
prejudice.
Yes.
So that is why I asked them, but they have made that again the wrong
So
calculation.
now we have corrected.
How much it comes?
60 lakh 10,000.
We don't know, we have not seen. Whatever payment your lordship thinks they should pay.
Because without these documents out there, it becomes very difficult.
They should have filed all the documents.
But
They-
the
but-
plaint is being relied upon by you.
Your lordship will have to see the plaint, your lordship will have to see the WS decree and the judgment.
Yeah, how does the trial court come into that finding? The executing court has come into that finding of 4 crores.
That's all the calculation made.
Calculate, there is nothing, there is no calculation
your
mentioned in the order.
Yes, the calculation we have given, that has been accepted along with our execution petition. Your lordship will see our execution petition at 19. And the relevant calculation is at page 23. And this is one that we have, and I'm prepared to defend it.
Now, how does the trial court come into the executing court come on the basis of this? How does it apply its mind to this calculation? There's
As-
nothing mentioned out there in the
Well-
first, although they have the executing court has passed a long order,
Yes.
but how does it take into consideration this? Nothing has been mentioned.
On the basis of, my lord, the judgment and decree. On the basis of the
Okay.
judgment and decree,
It's the basis of the judgment and decree. What is his understanding and my understanding, that will, I'll have to look into it.
that your lordship, I'm not saying that your lordship cannot look into. Definitely your lordship will look into, and definitely your lordship will examine whether the execution is being done in accordance with the decree or not. That
That's it.
nobody can deny that.
Yeah.
That your lordship can. Your lordship, he has dealt with at page, if your lordship will see. Page
No, page 152, how does the executing court come into 18%? Bring in 18%. There's nothing.
18% is there in the plaint itself.
Understood, maybe
Yes.
there, but how
Yes.
does the executing court come into 18% when neither the trial, because you see, it is the executing court, the trial court nor the first appellate court dealt with this 18%. The
18%
only
dealt with.
finding of interest given out there
lord-
is an person pertaining to 2% above the prime lending rate. That's
That is
it.
after that is pendential interest, my lord. Your lordship will kindly turn to page 50 at page 66. Page 66. This is the judgment, my lord. My lordship will kindly see. In result, the suit is decreed in favor of the plaintiff on contest with cost of recovery of 2 crore 26 lakh. This includes 18%.
Now, let us see, how does the trial court come into 2,26,000? Where is the finding of
I'll
2,26,000
show that.
as regards this?
I'll show that, my lord. That I think it will take some time for me to find out that specific part of the finding regarding 226, but the order that I have given, I've just placed with your lordship, and to get read with the plaint, and also order at page 67. 67. 67. The suit is decreed, but this has been decreed as per our plea. In their written statement, they never denied, my lord, the cost. They only said the interest should be.
No, kindly see what is the reading of issue number 12, page 48.
67.
48.
Just 1 second. Issue number 12, this is framed in such a way that it is deciding, or it is framed.
All interest.
All fees, even fees with interest, man.
Yes, that is what you see.
Yes.
Yes.
Separately, this issue, this was not raised, this was not denied.
No. There was no issue at all. That as regards the pre-issue,
No,
what
pre-issue
was
there was no.
so only issue was as to whether you were entitled to interest.
Whether the question is whether they have raised it in their written statement.
No. I'm not on that. Kindly see the issue. Issue page 48.
Let's check the.
Issue number 12.
Yes.
Because issue number 14 does not say a single word how he has arrived at 2 crore 26. Where the defendants are liable for payment of interest for non-settling of the plaintiff's claim, and because here, and or for non-payment of the plaintiff dues in time. So it concludes both. So under such circumstances, if this issue, the court have come and said 2% above the prime lending rate, it will be the prime lending rate on this amount will be total will be on the prime lending rate.
My lord, in my understanding, subject to what your lordship says, insofar as the 2% above that is concerned, because that will come only after filing of the claim.
No, that is not why it is saying. Only see the issue. Whether the defendants are liable for payment of interest for non-settling of the plaintiff's claim. That is first.
Yes.
And or the second part. Two parts of that issue number 12. The first part is which should have been settled as per 9(6) immediately within 30 days. And if it is not done, whether he is entitled to
But
interest.
those will, my lord, again, I mean, cost of repetition and saying those will arise only after the IRDA came into force. In 2001, it will not arise. So 18%
fact-
we have asked.
You see, the thing is whether IRDA comes or not, that is immaterial.
Yes.
The question is the court thought it the IRDA had come. The trial court thought the IRDA had come. Nobody had pointed out at that point of time the IRDA was only from 2002.
Now, let me, your lordship, just come to page 42 of that. Our case, what was our case, is entirely recorded to the court. The plaintiff could have earned a lot if it had received amount of claim within a reasonable time. Blockage of such huge amount for such a long period of time has affected the plaintiff's financial position very badly. The plaintiff, however,
Now, kindly see in the plain what is your relief at paragraph 20.
Yes.
Future interest at the rate of 18%.
Yes.
Now, this is the same 18% you added earlier
Yes.
also to make it a part of the principle.
Yes.
So, this will therefore the court, that particular question is a twofold question while framing the issue. First, as to whether non-settling of the claim he is entitled to interest, and also for not making the payment. That is why, and or for non-payment of the plaintiff dues in time. Why the second was necessary? If it was only the first one would have been otherwise over.
The issue was framed by the court. The issues are framed, of course, responsibility is always of the court to face the issue. But we all know it is framed by submission from both the sides. Both the sides gives and the court selects and frames. Now, my lord, claimed amount that we have given, I'm only saying that, has already been allowed, that has not been disturbed in the appeal. And I'm only saying that.
But the appellate court, with due respect, did not quantify that, which was quantified by the trial court.
Yes.
The appellate court did not do that. There the problem arises because of that. When a decree is passed for money suit, one has to pass a categorical decree to the effect that he is entitled to this amount,
Well,
which have not been done.
They could have challenged the appellate order to that extent, gone to Supreme Court, like we have gone a part of.
They have not done. They have not done the right for good reasons. They have not done. Why should? So that the plaintiff keeps on fighting out on that aspect.
Now, 18% is discussed in paragraph 32 at page 103 by the appellate court.
Okay, now tell me on the compound interest. Where is that?
Compound interest, your lordship will see the trial judge. The trial judge has quoted Vikram Green Tech case in paragraph 47 at page 113. 113.
Trial judge.
No, sorry. The appellate judge, appellate court.
What has he done? 113.
113.
Yes.
Vikram Green Tech. Copy the work. In case of Vikram Green Tech Limited and another New India Insurance, the same company, Limited, reported in 2009-5 SAC 599, the apex court has held that the rights and liabilities in an insurance contract would be strictly governed by the language of the contract, and there is no room for an equitable consideration in such matters. The observations made by the Honorable Apex Court in paragraph 16, 17, 18, and 19 of the aforesaid judgments are quoted herein below. I've given the judgment also. An insurance contract is a species of commercial transaction and must be construed like any other contract in its own terms and by itself. In a contract of insurance, there is a requirement of so field that is good faith on the part of the insured, except that in other respects, there is no difference between a contract of insurance or any other contract. The four essentials of the contract of insurance are the definition of risk, duration of risk, the premium, and four, the amount of insurance. Since the issuance of insurance policy, the insurers undertake to indemnify the loss suffered by the insurer on account of the risk covered by the insurance policy. Its terms have to be strictly construed to determine the extent of liability of the insurer. The endeavor of the court must always be to interpret the words in which the contract is expressed by the parties. The court, while construing the terms of policy, is not expected to venture into extra liberalism that may result in rewriting the contract or substituting the terms which are not intended by the parties. The insured cannot claim anything more than what is covered by the insurance policy. 12. 19. Oh, the document like proposal form is a commercial document and being an integral part of policy, reference to the proposal form may not only be appropriate, but rather essential. However, the surveyor report cannot be taken in, nor can it furnish the basis for construction of the policy. Such outside aid for construction of insurance policy is impermissible. So once the court says it is a commercial transaction, then commercial transaction, the calculation of interest is compound interest is the norm.
Then what do I do with the CPC? The CPC
CPC
says
will
that
not-
if it is, normally it is 6%, and if it is commercial, then it will go up, but it never says about compound
I'll-
interest. They have given you the prime lending rate.
Here, if your lordship will see the decree, page 67, just one line.
Hmm.
One line.
Page 66.
Page, my lord, 66. It's also in the decree. 2% above the bank lending as per IRDA, which is to be calculated as per bank norm. Now, bank norms is always compound interest. Because the other day, my lord, on this, I was seeing my passbook. Interest is added on whatever amount is there, then that becomes the balance. And next time that is taken, and then further interest is calculated. So the bank norm is interest, is compound interest. This is one that
Mr. Mishra, we will go by this issue number 12 only. However, the plaintiff is entitled to interest at 2% above the prime lending rate of the schedule bank.
What are your trip?
No, only that, because what has happened is this. If we touch on this aspect has been affirmed by the first appellate court. Although the first appellate court touches on the second aspect and says that he is only entitled to interest, but does not touch on issue number 10 and 14. And because of not touching on 14, one can give you the interest from the date of your information, which you have given from there, but on the prime lending rate at 2% above that. Nothing more than that. Because if we go for anything more than that, if I go to this place, the order, then it creates a lot of problem, because 2% above the bank lending rate as per IRDA means at that point of time IRDA is not there. But one thing one needs to very well take note of. Kindly see, however, the plaintiff is entitled to interest at the rate of 2% above the prime lending as on today, that is 7/3/2013. So he have fixed the date.
This is because so far as the interest up to the filing of the suit was included in Schedule B, I'm repeating it.
Yeah,
again and
no,
again.
that
Because
I
of
understood. No, that I understand.
Because of
Therefore, he has put it as per the IRDA.
subsequent.
Idea. Now, if the first appellate court does not decide anything on that aspect, how do you take care of that?
Paragraph 21, that's why I'm saying. The appellate court will decide if it is raised before it. If a point is not raised before it, your lordship has become aware of this because it's being raised before your lordship. Paragraph 21 of the appellate court, your lordship will see the appellate court has quoted, my lord, what they have challenged. Paragraph 19 dealt with all the issues.
That I read it.
Yes.
I
Then,
read it. I read
then
it.
20.
Yes. Yes.
87,
Yes, yes.
page 87, your lordship will see 21. Then the whole, all the grounds are there.
No, that I have to look into.
So if it is not challenged,
In fact, they have not touched 14. Issue number 14 have not been challenged at all.
and if the lordship will see 53,
Issue number 14 is not there. No ground.
no ground, no ground.
In issue number 14. And issue number 14 and 15 happens to be the main aspect.
And the trial and the appellate court has held that 15 has been decided correctly
Understood. But
at page 118.
yes, but if you see 15,
Yes.
14 and 15,
Yes.
that page paragraph 50 is the order. Is a fallout of what have been discussed. It has nothing else to do. This is only for the purpose of doing it. But it has to be based on the decision on the issues. Now, if you see 14 and 15, there's not a single word by the trial court to that effect that they are entitled to interest from the debt date. That is the big problem. But taking into account the issue 12, which has two aspects, one can very well take that first aspect has been dealt with in 12 as well also the second. Because if I otherwise you will face a lot of problems. That is why I am giving you, you may not get 3.25 less, but you are getting, otherwise there is a problem with the courts, the first appellate.
Your lordship is absolutely correct.
Because
12
14, the
contains
court does
both.
not do that.
Yes.
And 12, that is why 12 can be taken. 12 can be taken for pre-suit and one is after suit.
Yes, yes, your lordship. Yes.
So that is why
12
when
is correct.
12 has been decided in there, therefore you are going to get 14.25 or whatever it may be, or 16, whatever it may be, for the entire period from the date of the fire information till date. That is why I'm trying to say, not on the 18%. If you go by the 18%, you will be entrapped again. And you get there will be a stay to that order only because of that. So the only thing is this, because you can bring 12, that is the only way. Because 14, if he had stated a single line in deciding 14, 15 to that effect,
Yes.
that he is entitled to interest for that, or there was no payment made, and as such he's entitled, nothing, not a single word.
That is there. My lord, if your lordship will see, there one place in paragraph 50.
That 50 is not good. That 50 cannot be taken into account. That is only for the help of making that decree.
The one line is, if your lordship, let me just place at 116, page 116.
116.
116 of the appellate order.
116. Yes.
Second line from the top. Since the evidence on record suggests that there were only 414 number of logs burned inside the mill premises, hence the learned trial court was not correct in deciding issue number 9, 11, and 14 in favor of 20 by holding that 20 was entitled to decree of recovery of an amount of pertaining to 2,850 logs out of the total inventory of services. Therefore, the finding of the learned court stands in the POC and then reduced it to 414. Without that, the court was not aware. The court was strictly aware of all two parts. But then.
No, you see number E,
Yes.
that is at paragraph 52.
52.
The court affirms 12.
Yes. No, 12 is a 4.
12 is being affirmed.
Yes.
So you have to read 12 therefore in that manner.
Anyway, this apart, I just want to place one decision on the compound interest.
Yes.
Because here also the question of restitution to compensate for the loss arose. And this is Indian Council for Enviro Legal Action, 2011, 8 SCC, page 161. My lord, straight away I'll come to paragraph 181 at page 242. And for the facts, my lord, it's paragraph 2. There was chemical factory near a village. Before the chemical factory was set up, they were all right, healthy. But after setting up these chemical factories, they have suffered a lot. And it was for restitution of their suffering. So compensating them. In paragraph 2, your lordship will get. And the relevant for myself is at page 181 at page 242.
Yes.
Page 181. Compound interest is defined in Black Law Dictionary 8th edition at page so and so. Interest paid on both principal and previously accumulated interest. It's a method arriving at a figure which near the time value of money submitted under head 2 earlier. As noted, compound interest is the norm for all commercial transactions.
Mr. I would have if I was sitting in the appellate. But otherwise, kindly see page 168 and 169.
$168.
168. Of that judgment. Of that judgment, yes.
Oh, 168 I've seen, yes. I've seen.
That is the problem.
168 I have seen.
I don't know. I've not read it now.
No,
Whether
but then it will not come on in the way.
and more particularly how the court gives in this case is in 169.
Well, the answer is perhaps here. I may not be correct. Your lordship will kindly say. I'm just placing it. One reason the law has not developed in this is because of the wording of section 34 of the Code of Civil Procedure, which still proceeds on the basis of simple interest. In fact, it is the difference which prompts much of our commercial litigation, because the debtor feels calculated and assessed that to cause litigation and then to contest with obstruction and delay will be beneficial because the court empowers to allow only simple interest. A case of the law reforms on this is a separate issue. On the point under consideration, 69, I'm reading 169, which does not arise from the suit for recovery under the Code of Civil Procedure, interest power of the court and the principle of justice and equity are each sufficient to enable order directing payment on compound interest. The power of the court, the power to order compound interest as part of restitution cannot be disputed. Otherwise, there can never be restitution. Our case is like a restitution.
Understood, but for the trial court and the first appellate court.
Everybody can't do that, your lordship. In civil, your lordship knows. We are, I can say,
No, no,
the
in fact,
lighter side, jack of all.
no, in fact, recently, during the amendments which were being made to the commercial courts, I think section 34 has been suitably amended for commercial litigation.
But bank always charge compound. Of course, it is there in the agreement. Now, your lordship 178, if your lordship has seen, it's in 178
Of this
of
judgment,
the judge. Actually, 178 starts compound interest. To do complete justice, prevent wrongs, remove incentive for wrongdoing or delay, or to implement in practical terms the concept of time value of money, restitution and unjust enrichment noted above, or to simply levelize a convenient approach is calculating interest. But here interest has to be concluded on compound basis and not simple, for the latter leaves much uncalled for benefit in the hands of wrongdoer. Further, a related concept of inflation is also to be kept in mind, and concept of compound interest takes into account by reason of prevailing rates. Both these factors, that is use of money and inflationary trend as the market force and predictions work out. Some of our statute or law provide only for simple interest, not compound interest. In those situations, courts are helpless. And it is a matter of law reform that the Law Commission must take note, and more so because serious effect it has on administration of justice. However, power of the court to order compound interest by way of restitution is not fettered by any law. And if your lordship, your lordship will read with the trial court judgment, where he says it will be calculated at bank norms, it becomes clear that it is compound. This will be my submission. This will be my submission.
this is an application under Article 115 of the Code of Civil Procedure, challenging the order dated 18/12/2023, passed in misc case number 24/2021, arising out of title execution case number. How much? 3. Title execution case number
3 of 2020.
3/2020. These people, they don't write it all. 3/2020. Whereby the application so filed by the petitioners herein, who were the judgment debtors, was rejected. Holding inter alia that the calculations so made in the execution application to the tune of rupees 4,73,473,00565 plus cost awarded in the decreed amount and the cost of the execution has to be paid by the judgment debtor oblique the petitioner herein. I've heard Mr. D. Mojumdar, the learned senior counsel, assisted by Mr. R. Batra for the petitioner, and Mr. D. Mishra, D.K. Mishra, the learned senior counsel, assisted by Mr. B. Prasad, appearing on behalf of the respondents. The issue involved in the instant application is to what interest the decree holder, oblique the respondent herein, would be entitled to. And what would be the principle and what would be the actual amount which is required to be paid by the decree holders, by the judgment debtors, for the purpose of satisfaction of the decree as it presently stands. For the purpose of deciding the same, it is relevant to take note of certain factual aspects which led to the filing of the instant application. The respondent herein is a partnership firm registered under the Indian Partnership Act 1932. Now you are not in business, no? You are still in business? Means as a veneer mill? No.
I know it.
That has been closed. Nowadays you don't. The respondent was running a veneer and sawmill situated Dihingyagaon, P.O. Silonizan, within the jurisdiction of Bokazan PS in the district of Karbi Anglong. The respondent had taken an insurance policy, and not one, how many? Had taken an insurance policy in respect to its mill premises. On 22/3/2021, at 0:30 hours, a fire broke in. 22/3/2001, at 0:30 hours, a fire broke in, wherein as per the respondent, all the logs lying in the open, excepting one log, was completely destroyed. The judgment debtor were informed as per the statements made in the plaint. On 23/3/2021, 2001. This aspect was duly acknowledged by the letter dated 26/3/2001 by the defendant number 3 in the suit. It may be relevant to mention that on 23/3/2001, the surveyor so appointed by the respondents herein had visited the place and took photographs, examined witnesses, and obtained various clarifications and documents. What is the date of repudiation? There was no repudiation. In spite of subsequent to the state surveyor, subsequent thereto, the surveyor made various queries with the respondent herein. And thereupon, no steps was taken for the purpose of releasing the due claims of the respondent, for which a suit was filed by the respondent before the court of the Civil Judge Senior Division, Golaghat, claiming an amount of rupees 2 crores, 26,75,380 semicolon, future interest at the rate of 18% per annum from the date of institution of the suit till full and final recovery, cost of the suit, and for other relief or reliefs. In Schedule A to the plain, the plaintiff gave details as to how it assessed the value of the total value of the logs, which was quantified at rupees 167,33,986. In Schedule B to the plain, the plaintiff gave the details as to how, as to on what basis the plaintiff had claimed a decree for rupees 2 crores 26,75,388. for the sake of convenience, for the purpose, no, it is pertinent to mention herein that in Schedule B to the plaintiff claimed the amount of rupees, the claimed interest at the rate of 18% per annum from 22/3/2001 till 13/3/2003. That is the date of filing of the suit. To the said suit was registered and numbered as money suit number 9/2003. The defendants in the said suit, who were the plaintiff petitioners herein, filed a written statement denying any liability on various grounds. On the basis of the pleadings, as many as 15 issues were framed. For the purpose of the adjudication of the instant proceedings. Issue number 12 and 14. 14 and 15, all Roman, huh? 12, 14, and 15. Being relevant, are reproduced herein below at 848. From the above quoted issues, it would be seen that issue number 12 dealt with two types of interest. The first pertaining to interest for non-payment of, for non-settling of the plaintiff's claim. And the second for non-payment of the plaintiff's dues in times. The issue number 14 relates to as to whether the plaintiff is entitled to the decree as laid for. And the issue number 15 pertains to as to what relief or reliefs the parties are entitled to. The learned trial court, by a judgment and decree dated 7/3/2013, decreed the suit in favor of the plaintiff, oblique the respondent herein. Let this court therefore take note of how the learned trial court decided the issue number 12, 14, and 15. In paragraph 48 of the said judgment passed by the learned trial court, the findings were arrived at that the plaintiffs, oblique the respondent herein, had duly fulfilled the demanded documents of the defendants to settle the claim. And even after 2 years of the request made by the plaintiff and the correspondence, the defendant did not make any heed, for which the plaintiff suffered financial loss. It was categorically observed that the inquiry was required to be completed within a month, but the defendant failed to do so. And it is under such circumstances the plaintiff had been compelled to file the suit. This finding is very relevant, taking into account that this aspect duly touches on the first part of issue number 1 or issue number 12. The learned first appellate goes further. Came to a finding that in terms with Section 70 of the Indian Contract Act 1872, the defendants were liable to compensate the plaintiff, and as such came to an opinion that the defendants are liable for making payment of interest for non-settling of the plaintiff's claim and non-payment in due time, which therefore touches on the second issue, second part of issue number 12. Though the learned trial court dealt with the regulation 9(6) of the Insurance Regulatory and Development Authority bracket protection of policyholders interest bracket regulation 2002, but the learned trial court categorically observed that the plaintiff was entitled to interest at a rate of 2% above the prime lending rate of the scheduled bank as on the date of the said judgment and decree, that is 7/3/2013. The findings of the learned trial court on issue number 12 has great relevance for the purpose of decision of the instant case. Inasmuch as the learned trial court duly dealt with why the said interest the plaintiff was entitled to and from when. While deciding the issue number 14 and 15 at paragraph number 49, the learned trial court only held that the plaintiff have been able to prove and establish that it was entitled to the recovery of money as paid for, whereas the defendant failed to establish that the logs and the timbers were valueless due to the exposure to the sun and the rain and attack of white ants. And further, the defendant also failed to prove that the logs and timbers were set on fire and willfully and intentionally destroyed for wrongful gain by the plaintiff. In the penultimate paragraph of the judgment passed by the learned trial court, that is at paragraph number 50, the learned trial court granted the decree as prayed for. However, only instead of granting future interest at the rate of 18% per annum, had granted 2% interest at the rate of 2% above the bank lending rate as per IRDA which is to be calculated as per bank norms as on 7/3/2013 on the decretal amount per annum with effect from the date of institution of the suit, that is 13/3/2003, till full and final recovery of the decretal amount. Being aggrieved by the said judgment and decree dated 7/3/2013, an appeal was preferred before this court, which was registered and numbered as RFA number 40/2013. This court, by its judgment and decree dated 17/11/2015 or 27/11/2015, interfered with the said judgment and decree passed by the learned trial court by modifying as regards the entitlement of the plaintiff in respect to the claims pertaining to the logs, inasmuch as the learned trial court granted the decree on the basis of 2850 logs, whereas the learned first appellate court, this court, had granted the entitlement of the plaintiff in respect to 414 logs. In the same judgment and decree passed by this court, at paragraph number 21, the various grounds of objection which were taken in the first appeal were quoted. Ground number Roman 3, the 13, was the ground of objection taken in respect to issue number 12. This court, while deciding the said appeal, formulated 5 points for determination the point for determination number D and E are relevant for the purpose of the instant decision. The point of determination, capital D and E, reads as under D. whether the plaintiff is entitled to the principal amount claimed in the suit under Exhibit 44 and 45, and if so, to what extent? Question mark. And E, whether the plaintiff is entitled to claim interest? Question mark. Well, deciding the point of determination, D, this court categorically came to an opinion at paragraph number 50 of the said judgment and decree to the effect that the plaintiff oblique the respondent herein failed to prove that 2850 numbers of logs were stacked inside the mill premises and had been burnt in the fire inside the premises. It was categorically opined that since the evidence on record suggested that there were only 414 number of logs burned inside the mill premises, hence the learned trial, and hence observed that the trial court was not correct in deciding the issue number 9, 11, and 14 in favor of the plaintiffs by holding that the plaintiff was entitled to the decree for the recovery of an amount pertaining to 2850 logs out of the total inventorized log numbering 3050 as per the stock register. Therefore, this court interfered with the said issues to that extent. While concluding the said point of determination, that this court categorically observed that the amount awarded to the plaintiff under the impugned decree shall remain confined to 414 numbers of logs only. The point of determination, number E, as to whether the plaintiff was entitled to the claim of interest. In paragraph number 52, 53, and 54,
I just want to bring it this part of the decree. We have challenged and that
no, I'm going to say that.
and it said
No,
122.
I will go into that. First, let me
Mamala.
complete this,
Yes.
because you have filed an SLP against 2850.
Yes.
That I know. And there is a pass by which it has been.
Yes.
So let
Because
me,
of that order, we are before the
no, I know that. Let me come to that. I dealt with in paragraph number 52, 53, and 54. And being relevant, the same is reproduced here in under. In 116, 117, 118. From the above quoted paragraph, it would be seen that this court had duly taken note of two aspects of the matter. The first, the entitlement of the plaintiff to claim interest from March 2001 on the basis that the settlement after the surveyor's report should have been within 30 days. And the second is as regards the future interest also. This court also finds it very pertinent to take note of that this court had affirmed that part of the decree in so far as issue number 12. It is, however, very pertinent to mention that this judgment and decree passed by the learned trial court, by this court, dated 7 27/11/2015, passed in RFA number 40/2013, have not been put to challenge by the defendants, the petitioners herein. However, the plaintiffs, that is the respondents, have put to challenge that part of the said judgment and decrees insofar as interferes with the entitlement of the plaintiff as regards 2850, which was interfered by the first appellate court and only given for 414 logs. The said appeal,
Page 120.
where is that order?
120.
126.
20.
The said appeal is pending before the Supreme Court in SLP bracket civil. What is the number? This number is no longer there. What is the number?
Yes, 28277.
28277/2019. Full stop. I think now it has been, this is a long time order, na? It has been now numbered as a civil appeal, na? Get the
Should have
final.
been, but we have no information we asked.
Huh?
Should have been registered as civil appeal by now.
It has been now, obviously, because the leave already granted in 2019.
Thank you.
And full stop. By an order dated 6/12/2019, the Supreme Court had granted the leave and clarified that the grant of the leave shall not come in the way of the disbursement of the claim which have been allowed by the High Court in favor of the appellant, that is the respondent herein. It is under such circumstances on 4/6/2020, an application was filed seeking assistance of the learned executing court for the execution of the decree passed by this court on 27/11/2015 in RFA number 40/2013. Claiming an amount of rupees 4,73,473,00565, which was the amount with interest and cost till 31/5/2020, semicolon, further interest as per the decree to be calculated in due time. In addition to that, the execution was also sought for recovery of the cost awarded of an amount of 21,211, as well as also for the purpose of carrying out the, as well as also the cost for the purpose of carrying out the execution of the decree. To the said application, a schedule has been enclosed giving the details on the basis of which the amount was duly claimed. The petitioner herein, take a look here, the said application was numbered as money execution case number 3/2020. The petitioner herein filed an application, filed an objection to the said execution of the decree on the ground that a calculation which was calculation which was made, and on the basis of which the claim was made, on the basis that the claim, the decree sought to be executed was not in terms with the judgment and decree passed by the learned first appellate court. Subsequent thereto, this objection was converted into an application under section 47 and registered as misc case number 24/2021. Misc 24, na? 24.
Number I have got here, civil appeal number I have got.
Oh,
It's mentioned in the thing only, execution petition. Civil appeal 9334 dash 9335 of 2019.
SLP number. Huh? Misc case number 24/2024. The learned executing court, thereupon hearing both the parties, passed the impugned order, and it is under such circumstances the present proceedings under present revisional proceedings under 115 have been, and under such circumstances the judgment debtors have invoked the present proceedings under section 115 of the Code of Civil Procedure 1908. We come back in 5 minutes. In the backdrop of the above, let this court therefore take note of the submissions which have been forwarded by the learned counsels for the parties. Yes, what is your submission?
My lord, as that Because the rate of interest is charged. The subject is that IRDA will provide on the bank. The clause 9 is bank. We have given a document from the bank. It says that it is 8.50. So
The-
2% above
That
8%.
that was not a, yeah, that's a term deposit rate, 8.50.
My God. Wait, but it is the colored bank rate which the RBI.
And what else?
And secondly, my lord, the compound was calculated with my it includes the compound interest that put to it. But you'll find in my additional affidavit, my lord, we have include the
Okay.
charge.
Mr. D. Majumdar, the learned senior counsel appearing on behalf of the petitioner submitted that as per the judgment and decree passed by this court, the rate, the interest rate would be the bank rate. He submitted that on 9th of April 2010, the benchmark prime lending rate system, which was introduced in the year 2003, was no longer holding the field. And the rate has to be, the bank rate has to be on the basis of the base rate. More particularly with effect from 1st of July 2010. Drawing attention to the Annexure D to the additional affidavit filed by the petitioner on 2nd of April 2024. The learned counsel, senior counsel submitted that at that relevant point of time, more particularly for the month of February 2013, 13. When was the judgment delivered? 13. 13, na? February 2013. The maximum base rate was 10.50 and the minimum base rate was 9.70. He further submitted that the term deposit rate at that relevant point of time was 9%, which was the maximum, and 7.50, which was the minimum. The learned counsel, senior counsel further submitted that a question of calculating the entitlement, or more particularly the interest on the bank prime lending rate, could not have been taken into account, in as much as the prime lending rate concept was no longer holding the field at that relevant point of time. The learned counsel for the senior counsel further submitted that if the calculation is looked into on the basis of which the plaintiffs oblique the decree holders have asked for the amount, the same is based upon compounding the interest, which is completely foreign to the directions passed by the trial court as well as the first appellate court. He submitted that this is a specific, the instant proceedings arises out of a proceedings under the Code of Civil Procedure 1908 and Section 34 of the said code does not conceptualize the awarding of compound interest Anything else?
There is this commercial interest claim matter. Even the page 66 says per annum. So it doesn't say commercial compound interest.
I hope you don't make that submission.
And
That-
one
That per annum is disastrous for you.
more submission. We have taken internet submission. The review we have filed that is pending.
So what?
That meant to name it so that
We have nothing to do with the review.
I submit. The review is pending.
The learned counsel further submitted that a review application has been filed to the judgment and decree passed by the learned first by this court on 27/11/2015, which is presently pending, seeking clarification as regards the interest rate. Per contra, Mr. D.K. Mishra, the learned senior counsel appearing on behalf of the petitioner, on behalf of the decree holder, submitted that at paragraph number 18 of the plaint, the plaintiffs, oblique the decree holders, had categorically mentioned the loss it had occasioned on account of not being able to do business in respect to the loss, in respect to those logs. And thereby the plaintiffs have duly claimed special damages during the period from the date of the submission of the claim till the date of institution of the suit. The learned counsel further submitted that a perusal of Schedule B to the plaint would clearly show that 18% interest was calculated on the amount arrived at in Schedule A, and on the basis thereof, the amount of rupees 2,26,75,388 was arrived at. The learned senior counsel further submitted that the interference made by the learned first appellate court was only to the extent of the entitlement pertaining to 2850 logs, which the learned trial court had decreed. Whereas the learned first appellate court have held that the plaintiff was entitled to its entitlement on 414 logs. He therefore submitted that a claim as regards 18% interest which was the interest, which was in the form of a special damage for the period from for the period prior to filing of the suit and from the date of intimation, was not interfered with by the first appellate court. And in fact, the said aspect of the matter was never agitated in the first appellate court. The learned senior counsel further submitted that issue number 12, while being decided by the learned trial court, categorically held that the plaintiff would be entitled to interest at the rate of 2% above the prime lending rate of the scheduled bank as on 7/3/2013. Further referring to paragraph 52 to 54 of the judgment passed by the learned first appellate court, the learned senior counsel emphasized that the learned first appellate court affirmed the decision of the learned trial court in issue number 12. And therefore, whether the Reserve Bank had abolished the system of bank prime lending rate or not has no relevance, in view of the judgment and decree being clear on that aspect, he further submitted that this court, that the executing court is only to execute the decree as it is. And cannot go behind the decree. And as such, whether the Reserve Bank have abolished the bank's prime lending rate system is outside the purview of the executing court.
Otherwise also, yesterday they have filed an affidavit. If your lordship say what they are saying is not correct, their own document they have filed, my lord, on 8/4, one additional affidavit before your lordship.
But it is
My lord, this your lordship will see, this is their RTI reply at page 236.
Yeah.
Annexure D. This is what they had asked. The question is there, the prevailing banking rate, prime bank lending rate as on 7/3/2013, if bank lending rate and prime lending rate are different, then please just specify both the rates as so and so. Then on the right hand side, if your lordship will see, the base rate system has replaced BPLR system with effect from July 2010, and please refer to base rate mentioned in the weekly statistical supplementary enclosed. Further, this is assurance company that they are may be guided by following instructions. Master circular. We have taken out the master circular. This is before your lordship. Your lordship will see what is the base rate. What is
Where?
the base rate? Your lordship will see guideline 2.2. Second page 2.2. Base rate system has replaced BPLR system with effect from July 1, 2010. Base rate shall include all those elements of lending rate that are common across all category of borrowers. Bank may choose any benchmark to arrive at the base rate for a specific tenure that may be disclosed transparent. An illustration for computing the base rate is set out in Annexure 1. Banks are free to use any methodology as considered appropriate, provided it is consistent and it is eligible for supervisory review, etc. Then your lordship will see 2.2.2. Bank may determine their actual lending rate on loan advances with reference to base rate by including such other customer specific, etc. Then 2.2.4, base rate can be only one base rate for each bank. Bank rate have freedom to choose any benchmark to arrive at single base rate, which should be disclosed transparent. 2.2.6, the last one. Since the base rate will be minimum rate for all the loans, banks are not permitted to resort any lending below the base rate. And we have enclosed, my lord, the SBI letter. So therefore, these are irrelevant.
no, in fact, this document is already there. I've seen this. Only see this document which I have seen it. Only see here. This document is already there. Yes, kindly come to page 224. Okay.
Yes. Yes. Yes.
This 2.224.
Yes.
Roman 8.
This
is what you have
Minimum
stated.
rate for all the banks are not, yeah, this is
Yeah.
there.
This is exactly it.
Yeah.
So it is already there
Yes.
on 9. It is already given on 9th of here. This that. He further submitted that it is not that there is no prime lending rate. Referring to the circular, the circular dated 9/4/2010 of the Reserve Bank of India, enclosed by the petitioners in their additional affidavit. He referred to clause Roman 8 and submitted that the base rate would only be the minimum rate for all loans. Banks are not permitted to resort to any lending below the base rate. The same. Therefore, does not apply to prime lending rate, which would be obviously different from the minimum lending rate. The learned senior counsel therefore submitted that the prime lending rate have been duly certified by the
Chief Manager, State Bank of India.
Chief Manager, State Bank of India, which have been brought on record by way of an affidavit filed by the petitioners, by the respondents on 28/3/2024. Certifying that the prime lending rate of the State Bank of India as on 7/3/2013 was 14.45% per annum. He therefore submitted that the plaintiff the decree holders were entitled to interest at 16.45% as per the judgment and decree passed by the trial court as well as also by the First Appellate Court. The learned senior counsel further submitted that the degree holders are entitled to interests which is to be compounded, taking into account that it is the bank norms which stipulates compounding of the interest. The basis on which, the edifice on which the said submission is being made is on the basis of paragraph number 18 of the claim. The observation so arrived at in paragraph number 50 of the trial court judgment and also refer to the judgment of the Supreme Court in the case of Indian Council for Enviro Legal Action versus Union of India and others, 2011, 8 SCC 161. more particularly refer to paragraph 178 to 181. Anything else, Mr. Mishra?
My lord, specifically, my lord, I'd say, my lord, that since the decree holder has sued them for non-performance of their duty under the Contract Act, basically the suit is for restitution of the losses that I have suffered. And therefore, the provision of CPC may not come in to, my lord, bar application of compound interest as held in Federal legal. Because that's very clearly mentioned here in the this aspect below that paragraph 180, the last line, 80 of the last line starts from however, the next page, the power of the court to order compound interest by way of restitution is not fettered in any way. Because even section
No, there's no quarrel with that proposition. Mr. Mishra, if I was sitting instead of my brother, I would have granted you that. But I'm not here.
that's why I said everybody can't be.
In fact, the concept of damages, special and general damages, this is a case of which will come as a not only as it's not a special damage, it is a case of a general damages also. One has to give it that what has happened out there.
But the only thing I want to cling on is mentioned in the judgment and decree of the child court, which says the calculation will be as per bank norm.
That I've already mentioned.
Specifically,
No, that I've mentioned.
because
No, that I've said. So I already said, no, as per the bank norm.
Yeah.
I mentioned
That.
That I've already. Upon hearing the learned counsels for the parties on the basis of the contentions referred to herein above, the following points for determination arises for consideration. Whether the learned executing court was justified in passing the impugned order without taking into consideration the whether the impugned order passed by the learned executing court suffers from any jurisdictional error on the face of jurisdictional error in view of the observations made by the learned trial court in respect to issue number 12, as well as the observations made by the first appellate court in respect to the said issue. Number 2, whether the learned executing court could have entered into the aspect pertaining to the abolishment of the bank prime lending rate system an introduction of the base rate system by the Reserve Bank of India while executing the decree. This court had, in the previous segments of the instant judgment, have dealt with as to how the learned trial court had decided the issue number 12 and what issue number 12 stood for. Issue number 12, the decision of the learned trial court in respect to the issue number 12 categorically shows that the learned trial court duly had taken note of two aspects of the matter. As to whether the defendants were liable to pay payment of interest for non-settling of the plaintiff's claim and or for non-payment of the plaintiff dues in times. In the trial court's judgment, it was held that the plaintiff suffered financial loss on the ground that even after 2 years of the request made by the plaintiff, the defendant did not pay any heed. A perusal of the judgment of the trial court in respect to issue number 12 as well as also in the issue number 14 and 15 does not show that the learned trial court had taken into consideration what was the loss suffered by the plaintiff on account of blockage of such a huge amount of the blockage of the claim amount for a long period. Which was primarily contended in paragraph number 18 of the plaint.
23 of plaint. 23 and their reply is in say, paragraph 30.
Okay.
I feel details in the.
The learned trial court only held that on account of the delay in settling the dues to the plaintiff, the plaintiff is liable to be compensated in terms with Section 70 of the Indian Contract Act 1872. And as such, held that the defendant oblique the judgment debtors were liable to make payment of interest for non-settling the plaintiff's claim and non-payment of the due time. It is also seen that though the learned trial court referred to Regulation 96 of the Insurance Regulatory Development Authority bracket Protection of Policyholders Interest bracket Regulation 2002, but the trial court held that the plaintiff is entitled to interest 2%, it will underline word, 2% above the prime lending rate of the scheduled bank as on 7/3/2013. In the judgment and decree of the First Appellate Court on 27/11/2000, rendered on 27/11/2015, the court and bench of this court categorically held that since the rights and obligations of the parties are governed under the contract having a commercial angle in the matter, it was obvious that the delay in settlement of the claim would have adverse financial implications on the insured, and the records did not disclose any justifiable grounds for the insurer to delay the settlement of the claim over a period of 16 months after the claim was lodged.
If the same form was submitted subsequently,
It was also observed that the insured would be entitled to claim interest on the claimed amount if the settlement is delayed beyond 30 days from the date of submission of the surveyor's report. The coordinate bench of this court affirmed the findings of the learned trial court, holding that the plaintiff would be entitled to interest at the rate of 2% above the bank lending rate as per the IRDA regulations, with effect from the date of institution of the suit with a, that is 13/3/2003 till realization of the full and final amount. From the judgment passed by the learned trial court, by the coordinate bench, it is categorically seen that it has been held that the plaintiff is entitled to interest for a period when the claim application was not settled. And also thereupon, from the date of institution of the suit. This court, however, opines that neither the trial court nor the first appellate court had arrived at that the pre-suit interest would be 18%. Although the learned trial court, in its order, in paragraph number 50 of the judgment, granted the entire amount of, decreed the entire amount of rupees 2,66,00,000, 26,75,388, which was inclusive of 18% interest. But the first appellate court did not notice the said aspect of the matter and had only held that the plaintiff was entitled to interest, entitled to the amount as per in respect to 414 logs and not on 2850 logs.
I just point out in paragraph 32, that
That I've seen.
notice.
It has been noticed, but it has not been had not done anything on that.
So, yes, just mentioned.
That I have noticed. As the interests which have been arrived at by the learned trial court as well as the first appellate court, to the extent only of 2% above the prime lending rate, above the bank lending rate, as per the IRDA, the bank lending rate. The interest pre-suit on these 414 logs has to be on the basis thereof, on the basis of issue number, has to be based on the issue number, on the basis of issue number 12, which have been decided by the learned trial court as well as the learned first appellate court. This court also finds it very apposite to observe that the learned trial court, first appellate court confirmed the judgment and decree, confirmed the findings arrived at by the learned trial court in issue number 12. And as such, while confirming without any interfering, it has to be therefore understood that the prime lending rate, that the interest to be given to the decree holders would be 2% above the prime lending rate of the scheduled bank as on 7/3/2013. The next question arises as to whether the learned trial court, executing court ought to have taken into consideration about the abolishment of the bank prime lending rate system by the circular dated 9/4/2010 by the Reserve Bank of India. First, this very aspect of the matter was never brought to the attention of the learned executing court. Secondly, when the decree categorically mentions that it is the prime lending rate 2% above the prime lending rate, in the opinion of this court, the learned executing court would not be within its jurisdiction to traverse beyond the said decree so passed. Under such circumstances, these aspects of the matter could not have been taken into account by the learned executing court, and rightly the same was not taken into consideration. In addition to that, this court also finds it very pertinent to observe that a perusal of the circular dated 9/4/2010 also shows that the base rate is the minimum lending rate, and the same cannot be equated with the prime lending rate. There is no bar on the part of the Reserve Bank of India, on the part of the scheduled banks to charge other rates, but have to be only transparent with the base rate. Under such circumstances, the said submission made by the learned senior counsel appearing on behalf of the petitioner as regards the base prime lending rate system having been abolished by the circular dated 9/4/2010 is totally misconceived in the present facts. In the backdrop of the above, now the question arises as to whether the learned trial court executing court was justified in passing the impugned order on the present facts, and thereby rejecting the said application. For deciding as to how the interest is to be apportioned, applied and apportioned, this court finds it relevant to take note of the judgment of the Supreme Court, the judgment of the Constitution Bench of the Supreme Court in the case of Gurpreet Singh versus Union of India, reported in 2006, 8 SCC 457, whereby the Supreme Court dealt with the manner in which an interest, dealt with how a decree where interest and cost and interest have been also imposed, is to be apportioned. In this regard, this court finds it relevant to quote paragraph 26, 27 of the said judgment. 52 is pertaining to any payment made on the upper. I think 26, 27 is the where it categorically explained how it is to be done.
Sure.
Anyways, at 2, let me dictate the remaining. I would not spoil your lunch.
Your lordship will continue at 2.
Remaining, I have to give.
Yes.
Yeah, I'll
The
give
only
it.
thing my learned friend will be there, because I can be.
No, I propose I'll give this, and then I'll say, then on the basis of this court I'll direct the trial court, executing court to proceed with the execution in accordance with the above what I. Making it clear that you will be entitled to interest at 14.26%, 16.25 or 14.
14 plus 2%.
16.25 from the date of your claim petition
Incident.
incident.
1 month after.
That's what we are saying of the lord.
No, it will be, but the first appellate court have said 30 days from the date of the surveyor's report.
Surveyor's report, my lord, came in 20, after we filed. After we.
No,
filed.
no.
18th foot. Surveyor's report came on 18th foot, which is 2000.
No, there is,
That is there.
And the suit was filed in 2003.
2003.
No, you have stated in your claim when the surveyor's report has come.
Lord, I'll just to their statement. What are you saying of my? There,
In the plain, you have stated,
my lord, if your lordship will see their WS, very clearly mentioned. Paragraph 33.
what does it say?
It says, my lord, thereafter on 31/3/2003, the surveyor submitted his fire loss survey report under policy so and so, covering the log in open, pond, and pond timbers, and also stock water respectively. So we had filed it by 13/3.
No. I think it will be 1 month from your date of your claim. After, no, why I'm saying so? Because as per the regulations, whatever may be,
Yes, that out.
they are to do it within 1 month, surveyor's report.
Yes.
So the surveyor's report is their business.
Yes, but then.
So therefore, they delayed in getting the surveyor's report. That is their lookout.
So then it will be 22/4,
22/4,
2020.
Ah.
2001.
2000. So it will be 22/4/2001. The surveyor's report, because he did not submit the report.
Yes.
It is he who has appointed.
But then
It is there.
they did not submit the document as requested. by
There
the
is a
surveyors.
finding that we have done everything.
Claim is.
No, all these things you should have raised in the trial court. I can't help you.
Now, since this
Because
man-
here it says about 30 days. What do you do?
30 days from the date they submitted the claim. They submitted the claim form in 46,002 claim form.
Okay, just after lunch, you show me where they must have stated in their claim something.
We have given a copy of the claim form we have brought.
Those were not raised. It's
It's a matter of record. This paragraph. It is not in dispute that as per the IRDA regulations, the insured will be entitled to claim interest on claimed amount if the settlement is delayed beyond 30 days from the date of submission of the surveyor's report. So that finding is there.
Before that, one line before that,
Above this, there are 53.
53 last line.
Last. Records don't disclose any justifiable ground for the insured delay the claim over a period of 6 months after the claim was resolved. Yes, it is there, madam.
So this finding, we can give 16 months from that. I think this is the only way out. While having lunch, the only way out I found is this 16 months.
16 months.
16 months prior to the delivery of judgment, prior to filing of the suit.
Yes.
I think that is the only way one can take,
Simple.
simple way, because this is what has been given.
That finding.
New years.
From the above judgment quoted, from the above paragraph of the judgment of the Constitution bench quoted, the Supreme Court categorically observed that though the normal rule with respect to the money decree is the apportionment of the payment towards satisfaction of the rule of the interest in the first instance, and then towards the principal. However, the same became inoperative with the amendment of Rule 1 of Order 21. It was therefore observed that in cases of execution of money decree, interest ceases to run on the amount deposited to the extent of the deposit. It was clarified that if the amount falls short, the decree holder may be entitled to apply the rule of apportionment by apportioning the amount first towards the interest, then towards the cost, and then towards the principal amount due under the decree. In the instant case, if this court again recapitulates the facts, it would be seen that the first appellate court held that the plaintiff was entitled to the amount in respect to 414 logs. In paragraph number 53 of the judgment of the first appellate court, the first appellate court categorically observed that there was a delay of 16 months after the claim was lodged. Therefore, this period of 16 months,
Yes, I just point out, your lordship will kindly see, this is the observation which was made in paragraph 52, 53, which your lordship has pointed out. It's just an observation. Now, if your lordship will turn to page 118. 118,
yeah,
fourth line from the top, if your lordship will see. As such, I am of the considered opinion that the learned trial court has rightly decided issue number 10, 12, 15 in favor
understood,
of
Mr.
the
Mishra.
plaintiff.
That is aspect is understood, but that
No.
is the biggest problem out here with this judgment. You may seek a review which they are seeking, you may help it out.
That, my lord,
That is the
whatever
only way
that,
out.
that I have no. I
Because
cannot
otherwise,
support.
the interest is on that issue is only as regards the prime lending rate.
What I'm trying to point out to your lordship, that there is a categorical directions contained in this, that or finding or conclusion that I am entitled to interest with effect from the date of institution of the suit in just above paragraph 50. Only this one I want to point out.
Para?
Lordship may note. Paragraph 54 only, which I was placing, just rightly decided so and so awarding interest at the rate of 2% above the bank lending rate as per IRDA regulation with effect from the date of institution of the suit till realization. Now, if, my lord, with all respect, if your lordship makes any modification to this,
I'm not. You are going to get. No, first I have to make it a principle, no?
Well,
Kindly understand, these 16 months I'm making it a principle for you. So that on that basis, then they can, because the amount which is the decreed amount will be the principle. I'm not saying that you are not entitled, you will be entitled, but first one has to, you cannot be entitled. If I count the interest from there only, then your principal will be reduced.
I'll leave it to lordship.
So that is what. Now, 16 months after the claim was lodged. Under such circumstances, it is the opinion of this court that the plaintiff public, the decree holder would be entitled to interest pre-suit. At the rate of 16.25%, 45%. For a period of 16 months prior to filing of the suit. This amount, which would be arrived at, would be the principal decretal amount. Thereupon, in addition to that, it is also seen from the judgment of the First Appellate Court that the plaintiff public, the decree holder would be entitled to interest at a rate of 16.45% with effect from 13/3/2003, which is the date of institution of the suit. This interest which will accrue has to be apportioned, has to be applied in terms with paragraph 26 and 27 of the judgment of Gurpreet Singh Supra. Meaning thereby, the payment suit which have been made from time to time has to be apportioned against the interest, and after the exhaustion of the interest, the amount has to be apportioned against the cost, and thereupon the payment has to be made. The apportionment can only take place against the principal. This court have duly taken note of. That on 6/9/2013, an amount of 15 lakhs was paid. The same amount of 15 lakhs has to be therefore first apportioned against the interest. If while apportioning the said interest, the interest amount is duly taken care of, thereupon the said amount of rupees 15 lakhs can be apportioned against the cost. While doing so, if nothing can be apportioned against the principal, or even a part of the principal, then interest at the rate of 16.45% would keep on accruing till the amounts which have been subsequently paid on 3/1/2020 of rupees 27 lakhs 5,902 is apportioned. Yes, yes.
It will be 32.
Huh?
It will be 32 lakhs 8,000 because they have not taken into consideration the TDS and the
Oh.
What is TDS we have not received, we have not received any money. And
certificate is there.
no, we have our 26A certificate. If we have to place now evidence, we have ready with 26A.
Total amount is 570. Total is
Uh,
32
uh,
lakhs 8.
It will last line 15 lakhs. Thereupon, all subsequent amounts which have been paid has to be therefore apportioned against any interest which had accrued on the principal, and the remaining interest and the balance interest taking into account that the said aspect can be duly taken care by the learned executing court. This court grants the liberty to both the parties to submit their calculations before the learned executing court on the next date so fixed. When is the next date fixed?
Tomorrow.
Tomorrow it would not be possible. This order you will get it after view. It's a pretty long order. I'll give it on. Fix it on 29th of April day. On which would be on 29th of April 2024. And thereupon the learned executing court can proceed with the execution in accordance with law. Next. Before this court also finds it very pertinent before concluding to deal with the submission of Mr. D.K. Mishra, the learned senior counsel, as regards the entitlement of the decree holder to compound interest. In the instant case, as this court had duly observed in the previous segments of the instant judgment, the suits which was filed in terms with the Code of Civil Procedure. The interests have been awarded as per the decree. without stating specifically that the interest to be paid is compound interest. Under such circumstances, unless the decree specifies that the interest to be paid is a compound interest, the executing court cannot deem that the interest decreed is a compound interest. Therefore, in the opinion of this court, while coming up to a specific finding as to what amount the decree holder would be entitled to on the basis of the decree, the learned trial court or executing court shall take it as a simple interest at the rate of 16.45% per annum.
It will be of no consequences, my lord, when the degree says calculation is to be done as per bank norms. Your lordship is rejecting that. That, because that your lordship has noted in my submission, therefore that has to be rejected. Since your lordship is.
So we
Guaranteed.
apply I think the Supreme Court can very well knows how to apply explanation 5 to section 11.
So that's okay.
The Supreme Court will know
My
that. how to
duty
apply.
to point out that.
With the above observations and directions, the instant proceedings.
Right.
Give it to the item 48.
Hey, itu motion kita lalu apa ni? Motion kita. Let me take care of the motions first. There are 2-3 motions. I'll take your matter at 3 o'clock. Yes, Mr. P. Sharma.
Actually, item 2, I was got from filing the counter.
Huh?
It was got from filing WS in the counter claim
Why?
because learned trial court
You filed it, yo? Yes, what is it?
learned trial court has considered this page number 31A lot. Stipulated here the fact is their lordship
Page?
31A.
Yes, what is it?
Yes. It is revealed plaintiff defendant of 1 to 6 are represented. Defendant number 4, 5, and 6 have filed joint WS. Plaintiff by filing straight for adjournment to file WS against contract. Defendant number 1 and 2 has filed contract on 8/9/2020. 8/9/2026. But we have not received the copy. We have received the copy later on. That is the crux of the case. On 8/9/2020 and stipulated time period to file WS against the contract claim is already over.
The prayer for adjournment made on behalf of the plaintiff by petition is expected as prayer of the plaintiff.
In the next page, lordship,
Hmm.
32, lordship, 32. This is the counter claim, lordship, 32.
Yes,
In later part, copy received
2011-2023.
2011-2020.
Then,
Then I have received a copy only on 2011-2002. We are under the impression that on 11/1 there is a valid reason, lordship. Both the parties were unwell, lordship. So we should not be prepared at WS, lordship. They should not sign the WS on that day, lordship. There is an application also. I'll begin for that day, lordship. So if we consider from 2011-2023, lordship, then 90 days will not be. It is not within a stipulated period on 11/1/2020. Here, on that day, we have filed application case number 61.
You should notice. When is the next date? What happened on 1/4?
1/4 nothing happened, Lordship.
Huh? What happened on 1/4? What is the next date?
11/5, Lordship.
Where does the plaintiff defendants reside? Respondents? Or Jalukbari?
Yes, sir.
1, 2, and 3 are, who has filed the written statement? Counter claim by defendant number 1.
Defendant number 1 to 1.
Third is by way of trustee. Where does it state? At Jalukbari. Okay. Issue notice making it returnable on. Next date is 11/5. Notice making it returnable on 6/5/2024. Steps be taken upon the respondent number 1. Why the others? These are
We have not
performed
claimed anything, Lordship.
against the respondent number 1. The issue notice only against the respondent number 1. Full stop. Returnable on 6/5/2024.
Sorry, Lord, 15/6. Next. 15/6, correct.
Okay. Issue notice making it returnable on 10/5/2021. 24. Against the respondent number 1. This court in the instant facts is not inclined to issue notice upon the performer respondents. The petitioner is directed to take steps by way of the stick, by registered as well as usual upon the respondent number 1. The petitioner is further directed to take steps by way of the stick routed through the registry of this court and file an affidavit of service on or before the next date. Taking into account that the next date fixed in the trial court is on
15/6.
15/6/2024. This court, for the present, is not inclined to pass an interim order. However, on the next date, this court shall consider passing appropriate. Survey will finish on the first day.
Okay.
Yes, what is this? What you are challenging?
Lordship, this title appeal was decided on 21/5/2018.
Ah,
And
Then?
the delay condemnation petition was filed on 6/9/2019.
Hmm.
Actual delay is 850 days.
hmm.
But the delay is condoned taking on account of the Article 150 of the Limitation Act, repeating that the respondent was not aware about the 50. So according to this delay is condoned 101 days.
Yes, so
Actually, Lordship, this notice was duly served. They received the notice. The respondent contested the case by way of raising counsel. But on the subsequent date and on the date of the final hearing, they remain absent according to the decided expert. So, Lordship, I'll show the order. The first Lordship will see the
no. You are the respondents in the appeal. You are the respondents in the appeal.
title appeal, I also appeal.
Your delay was condoned.
My delay is condoned. I am challenging the delay condonation order
Why?
because the respondent she has contested the appeal at the initial stage.
No, do you want that your delay condemnation application?
It's not my delay application. It
Whose
is filed
appeal?
by Respondent. Respondent of the title appeal.
They filed delay for what?
I have filed this petition challenging the delay condonation order.
Who was the appellant? Who filed the appeal? Who is Yamuna Sarkar?
Yamuna Sarkar is the appellant of the title appeal number 21, title appeal number 8 of 2015.
Hmm.
And Yamuna Sarkar is my mother. I am her daughter, Suniti Sarkar.
Uh.
And when she died, according as a legal heir, I was included.
Okay. Now,
Now this appeal was decided on 21/5/18.
21?
21/5/2018. So you could find it, page 12, and exact B is our judgment.
Then
Then look it, and initially
okay.
the respondent Amyopala Das has contested the appeal. Lordship will find this order, interim order, which was passed in the appeal. These are in the page number, vernacular page number 46. Notice to the 2, 4, and 5 are not retired. Learned advocate P.K. Chaudhary filed attendance on behalf of the other respondent. That is the respondent number 1 was represented in the appeal. And the Amyopala Das, who is their respondent, he was the respondent number 1 in the title appeal.
I don't understand, Mr. Muzumdar, one thing. If your appeal had been allowed,
Because expertly decided, allowed, thereafter, the respondent,
no, it was remanded back. Then the case record to the coroner given under the hand and seal. It is on 21st of October, May 2018. Then what happened?
then Lordship, this respondent has filed an application petition under order 41 rule 12/21 of the city for rehearing of the matter.
This one.
Yes,
Who filed? Oh, they filed.
they filed.
Okay, for rehearing.
Rehearing.
Then
In fact, there was a 850 days delay, but they have taken plea that they were not aware about the judgment. Accordingly, when they came to know, the delay was around on and ground of 141 as per the article 1 to 3 of the Limitation Act. And the learned trial court was satisfied. The delay was properly explained as the respondent was not aware about the decree. But the order which I'm referring, it shows that she was duly represented by her engaged counsel.
or you file objection. So why should we interfere?
Lordship, kindly peruse the page number 46.
40?
46.
Okay. Is there?
There is the, may I read out?
Yes.
The PO is on leave. Appellant site present. Notice to the respondent number 2, 4, and 5 are not retired. Learned advocate P.K. Chaudhary filed attendance on behalf of the respondent. The respondent number 2, 3, and 4. That is the respondent number 1 is represented. This is Amyopala Das is the respondent number 1. a similar order. Next order is the same. The last order is 15 to 16.
No. Your order 41 rule 19 application has not yet been decided.
Yes.
So there is only a section 5 application decided.
But it is
There's a delay of 141 days. The court has condoned. Why should we exercise 227?
But-
Absolutely no.
But-
Chalo. Let me
No,
dismiss it.
I-
No. This is a case, fit case for
why that, no,
dismissal.
my issue is that.
Understood, whatever may be. There's a delay of 151 days. The court have looked into and decided that yes, it is necessary. It's a discretionary power. The power under section 5 is a discretionary power to condone or not to condone.
I am not on that lot.
Then what are you?
They have cited the wrong reason that they were not aware, but this order reveals that they were represented.
For that, you can very well oppose order 41 rule 19. You see, you are coming out here that you see the question of not being represented, they have taken the ground. Now, these, whether you have taken ground that or not, that is the ground on which order for the court had proceeded ex parte during process, had passed the judgment and decree saying that none has appeared on behalf of the respondent. If you see the decree which has been passed by the first appellate court, it has been said for the respondent none.
But in the paragraph, it is also stated that notice was duly served.
So under such circumstances, you still have an opportunity of opposing under the in terms with the application under order 41 rule 19. You oppose that. I give you this thing. This thing I'm dismissing it. And you go and oppose order 41 rule 19 on whatever grounds you have. That they were duly represented. That is a different aspect. But this is a delay condonation. The court have duly taken note of. 141 days.
Lordship, I'm not opposing, I'm not contradicting, but
Well-
when deciding the delay condonation application, this order passed by the learned civil judge.
Should not influence the order 41 rule 9. That's all. You oppose that, whatever you have.
Then the liberty may be given to file application under.
They have already filed. You file your objection. Isn't that they have filed? That is their main application. Only see the application. The application is that it is annexure. This one, order 41 rule 21, page 22, annexure B. You will file objection to that. The learned counsel appearing on behalf of Mr. F.Z. Majumdar, the learned counsel appearing on behalf of the petitioner submits that withdraw dismissed, submits that taking into account that the order being passed by the trial court, by the first appellate court, that is the court of the civil judge senior division Goalpara, in misc case number 22/2022 is an order passed under section 5 of the Limitation Act, thereby condoning the delay, which is a discretionary jurisdiction. He would not like to further proceed with the instant proceedings. He, however, submitted that the petitioner herein, who is the appellant in title appeal number 08/2015, be permitted to file objection to the application under order 41 rule 21 filed by the respondents in the said appeal, being registered at misc case number 57/2015, and the observations made in the impugned order dated 11/1/2024 should not influence the learned first appellate court in deciding the said application. Taking into account the said submission, the instant application stands closed on withdrawal. Full stop. This court further observes that in the circumstance, the application being misc case number 57/2015 has not yet been decided. the petitioners herein would be at liberty to file their objections within 15 days from today. And it is further observed that the order dated 11/1/2024 passed in misc case number 22/2022 shall not influence the learned First Appellate Court in deciding the said application under Order 41 Rule 922 being misc case number 57/2015. Apo, baki matter kitna? Madam, I'll take your matter later on. This I have asked every time these people keep on changing, they don't know. I have to repeat it, the same instruction twice the time. Take your matter.
Item number 4.
Pudi lo bono and look. Yes,
I don't expect the right of book. Dated 80,000. We had filed the proper application for in that it's not made the but I don't get that it's not so again before
okay, at the request of the learned counsel for the petitioner matter stands adjourned to be discussed after 4 weeks. Yes, madam, what are you challenging?
I pray that the matter may be taken up immediately after vacation, my lord. What has happened here? I will try to show the reason, my lord. What had happened? Because of artificial flood, my chamber was shifted and most of the bricks got mislaid, my lord. I tried my level best to get the copy of the petition, and I have in fact applied for the certified copy, my lord, immediately after vacation, your lord, because that is my predicament today.
Where is your application?
Lord, I have already submitted, my lord, because of my predicament is that, my lord, due to artificial flood, my lord, my chamber got shifted and some of the bricks got mislaid, my lord. I tried my level best to get hold of that.
Madam, you tell me, you are against an order by which your application for sending to forensic
Yes,
was rejected.
from memory, I am saying, my lord.
Absolutely. Now, the question is, how without filing that application under Order 26 Rule 10A, this court should exercise the jurisdiction?
Order 23 rule
You have
10
not filed that application?
No, order 23 rule 10 application was there. So far, my memory goes, my lord. Well, I will submit, my lord, immediately after vacation, matter may be posted for admission, my lord. Because My memory says that for the count that I never said, plaintiff never stated in their plaint regarding the former certified copy. And that is why the court rejected the petition. So unless the plaint is in, my lord, I cannot make any suggestions to them.
Okay, madam, we'll extend, we will send it some other time, but I'm not extending the interim order.
Well-
It's the matter after how much? 2 months, 2 years?
My lord, immediately.
It's the matter after 2 years.
Lordship may not be pleased to get my lord, because
I'm not going to extend if you don't know anything.
only for this week, my lord.
Okay,
Only
whatever
for
may be.
this week, my
It's
lord.
the matter, the service is complete.
Yes, my lord.
Learned advocate has
appeared, my
entered for
lord.
the appearance for you by filing occurrence number. So taking into account that the service is complete, list the matter. List the matter again on 3rd of June 2024.
Extension may not be-
Madam, if you say about extension, I will say that I am not extending. It will have far-reaching consequences. Instead of that, you may always say that the judge has forgotten to written that.
Yeah, I am helpless, my, that is why I am.
So therefore, you be helpless before the trial court and say that, you see, the judge has forgotten to extend it. I will file an IA.
For a week, my lord, only for a week.
I feel fix it on 3-6. Don't worry. Next. Yes.
My lord, this case, we are actually the full execution. Your lordship will find another 10 and 11.
8,
Page 51 to 60. Silent page.
51 to
60, end of this.
which order you are challenging?
We are active with the actually input record of proceedings of the executing court,
Why?
because we have filed a civil division petition against the judgment of the appellate court. That's what.
Then?
And this proceedings was initiated by the opposite parties and before the learned executive court without issuance of any note. And another aspect is that
When was the decree passed?
20 June 2007.
And when was the execution filed?
It filed after
17.
in the year 17 after
So?
5 or 6 months.
Then
But we are not aware about the other proceedings.
execution.
Not
Is
only
it
execution,
required?
even the decree of the appellate court. Also.
Not necessary.
Our advocate has not informed
Not
us.
necessary. You
Disposal
see the provision of Order 41 rule. What is that provision?
order 21.
Order 21, rule 22,
Then? Not necessary.
within 2 years.
Then
But,
you, unless you get a stay out there in the revision application, nothing is there. No case.
by order dated 29 and another order was passed in with an IA for condonation. It was directed by the honorable court to raise the original civil division petition in due course. It is there pending before the honorable by CRP number 2 of the court.
Understood. Unless you get a stay out there, you cannot stall the execution proceedings. Or you file an application under Order 21, Rule 26 or 29 before the executing court. If you don't do, nothing can happen. You don't have any case out.
My lord, civil division is pending against the original decree of the appellate court before the honorable.
Understood. So get a stay there. How can you stall the execution proceedings by way of this proceeding? Tell me.
Debated prayer before your lordship.
Can you have two proceedings? Mr. Counsel, can you have one proceedings for execution and one proceedings for the revision against the appellate?
This original division was listed after 2 months of this, 2 or 3 months of this filing of this.
So now it is listed. So file an IA, whatever may be. But this court doesn't find any good reasons for interfering with this. What is this order of 8/9/2023?
Here in this, lordship may kindly take up the grounds for consideration before positive final order is matter.
Huh?
Because
Which is the order of 8/9/2023?
At page 50.
Which is the order? What is happening? Decree also is record reveals the decree has not yet taken step.
Not a
In the report of the civil, it is stated that decree could not be executed due to non-cooperation of the decree author. Hence, decree is directed to take fresh steps at effect. 8/9/2023. Where's that order of 8/9?
At page number 50, 5050.
The alters are repair. I've heard the learned. It's a landlord tenant.
No, it's the suit for
So right title is
right
there.
title is there.
So why are you filing revision?
Yes. Revision doesn't lie. It would have been a second appeal.
Uh,
But they have filed a revision, and those revision documents, nothing is annexed along with this application, nor even the number of the case has been mentioned in this petition. Today, for the first time, is submitting
No,
before the
it was filed prior
And
to-
Your Honor, in the suit, they have not filed the written statement. And they have participated in the title appeal. They have contested it. They were aware of the judgment and
not
decree.
contested, not
anyway, let us see what is wrong with this order. Directed to take necessary steps.
But prior to that, number of occasions decree holders have been.
This is an application this is an application under section Article 227 of the Constitution, challenging the order dated 8/9/2023 passed in title execution case number 5/2019. Why is this 5/19?
It was transferred from the district of corporate.
Okay, yeah, 19. Pending before the court of the Munsif, Baksa. This court have duly perused the order dated, impugned order dated 8/9/2023, as well as also the earlier orders passed in the state execution proceedings. This court finds no infirmity in any of these orders passed to exercise the jurisdiction under Article 227 of the Constitution. Be that as it may, it is the submission of the learned counsel. Under such circumstances, the instant revision application, stands being devoid of any merit, stands dismissed. Be that as it may, the dismissal of the instant application by this court shall not preclude the petitioner for approaching the executing court under the appropriate provisions of laws, seeking stay of the said proceedings pending in view of filing of the appeal, or seeking stay to the execution proceedings by challenging the judgment and decree passed by the learned first appellate. In time orders so passed stands vacated, and the same order dated
But
22/9/2023 stands vacated, and the parties are directed, and as the parties are duly represented, the parties are directed to appear before the learned executing court on 14th of May 2024 for further proceedings of the state execution.
Deeply obliged.
Yes, Mr. Sahu, what are you challenging?
Look at page 84. Order
What is this order?
3/10/2020.
Huh?
At page 84, we look. Look, they are seeking execution of the decree which will become. Earlier, they have come with an part, and later on they were not satisfied with the execution of the decree, and thereafter they filed a petition that decree has not been completely satisfied. Thereafter, the learned court below has
directed to press note, press delete against that I have come. And in my
So you
submission,
filed a 47?
actually,
You filed a 47?
not for only one objection, but
Why not a 47? It has been duly satisfied. If the decree has been fully satisfied,
Below.
your case is that the decree has been fully satisfied. Is the decree fully satisfied or not?
yes, earlier,
I'm asking you a simple question. Is
Yes.
the decree fully satisfied or not? As per you.
satisfied to the extent of
I'm asking you
Below.
whether the decree which has been passed by the court is fully satisfied or not.
the compromise.
Whatever may be, is it fully satisfied or not?
As per it, it was
No, read.
Below.
Read comes later. I'm saying about the decree passed by the trial court, whether it is satisfied or not.
that shows that has to be determined because what
How can the court determine? Under 47?
Yes.
Have you gone there? To show that satisfaction has been already accorded? If you have not done that, why is this court going to look into all these things?
Otherwise, I have eight one pertinent question related to
Pertinent questions are there on
Relating to law.
pertinent questions. We will have it in the cloud sometimes
Below.
when we have the time. But now ask my specific question to you is the decree satisfied? And it is for the executing court to do so. Now, therefore, you are to raise that issue that the decree has been satisfied. You see, a decree, unless it is satisfied, it is the duty of the executing court to keep on doing whatever is necessary. And he has to move all applications within 12 years. Unless, when the finding is arrived at by the executing court that look here, the decree is satisfied, matter. So, for him, decree has been not satisfied, so he's coming.
But for that purpose, it has to be for executing that part which you want to execute, that is required without under the
Which part? Have you raised that issue?
confusion.
Have you raised that issue in a
Yes,
47?
I have come for your lordship by way of actually
No, forget about all these things. Have you raised that issue that that portion is an inexecutable decree?
in the execution petition that part was not given. That
I'm
is
asking,
I
have you raised that issue that that part is not an executable decree? If you have not raised, why should I?
then I will permit the
Fantastic.
raise there.
The learned counsel, Mr. S. Rao, the learned counsel appearing on behalf of the petitioner submit that the decree partly
Part.
have been already satisfied and the remaining part of the decree cannot be satisfied taking into account that that portion of the decree is an inexecutable decree. Since any registration done in terms with the Registration Act 1908. This court had put a specific query upon Mr. S. Sahu, the learned counsel appearing on behalf of the petitioner as to was there such a plea have been taken in terms with an application under section 47 of the Code of Civil Procedure 1908. The learned counsel with all candor has submitted that such a plea have not been taken, but however, he seeks the liberty to do so, taking into account the above. This court, taking into account the said plea having not been taken, this court closes the instant petition. This court dismisses the instant application without prejudice to the petitioner herein to raise such plea before the learned executing court by filing an appropriate application. The interim order passed on so-and-so 4/12/2023 stands vacated and the parties are directed to appear before the trial court on 14/5/2024.
So in fact,
Anything else?
those plea they have already taken in the earlier round of litigation, and your lordship, while adjudicating the matter, has not considered the objection taken by them. So far as section 47 petition is concerned, they have already filed a section 47 petition. While that 47 petition was dismissed, your lordship,
While order that has not entertained the civil division petition, holding that the objection raised herein is not sustainable. If I may take a lordship to the
Earlier,
yes, earlier, relevant portion of the
No, earlier that part, because
my lord,
which was
page
satisfied.
51. No, my lord, it's a
The part,
decree, my lord, with regard to that they would not construct their boundary, their any construction without leaving 3 feet gap from the boundary or wall existing in between our land. Yeah, that was the my lord decree. And to that effect, there was a compromise petition filed by both of us. On that compromise petition, decree was passed. And in the compromise petition, it has been clearly mentioned, if the decrees, they do not demolish the part of the construction, illegal construction, then the parties are at liberty to file an execution case. If I may take your lordship to page 51, paragraph 11. I have heard the learned counsel for the petitioner, Mr. So-and-so.
the demolition, he will do it. He said at that point
Yes.
of time.
Yes, they have given undertaking, but in
Did
spite
you?
of that, they have not done.
Have you?
that portion was done with us.
No, my lord.
They were not satisfied, thereafter, writ was issued. That part was completed with us.
Then what remains?
That other part.
What other part?
They are coming in this thing.
Other part for what?
Below actually what happened. Okay. In the below plain, kindly come to page.
I'm not going to go to the plane.
Below.
Sorry.
No, what is the subject matter?
No
my
subject matter
case is
business.
below,
This court have already dealt with it.
my case is that without the decree which is now put to be executed is required to be registered.
Which
No,
one?
not necessary.
Which portion? Where's your application? Where you have stated that? Where's your application?
Below.
That it has to be registered. Show me.
That question was not.
Then
But kindly let me
this is to be dismissed. That day I have imposed a cost of 50,000 upon a lawyer. But yesterday I thought that okay, now this time before Bihu, there has to be a cost of 1 lakh upon a lawyer. So this is the fit case for you.
Below, kindly let me argue.
No. This is to be dismissed with cost of 1 lakh.
Of registration without.
Absolutely no. Why have you raised that issue?
Yes, below.
In your
My way
application?
of review,
No.
I have come before your lordship. And below,
You
earlier
come,
occasion,
whatever you come.
I did not get opportunity.
Lekho ke wo na lage. This is an application. Earlier, whatever you've given is gone. But this is an application under Article 2 to 7 of the Constitution,
If Lord,
challenging the order dated 3/10/2020 passed by the learned executing passed by the learned court of the junior division of case 2 in title execution case number 8 of 2011. The state application.
the order is of 2 parts. I have also filed an application. That was also
The
written.
state order has been passed in petition number 2 applications have been disposed of.
Yes,
Have been passed in 2 applications. The first application is an application filed under Order 23, Rule 3, read with Section 151 of the Code of Civil Procedure for recalling of the judgment and order dated 13/9/2005, passed in title suit number 82/2005, and the original decree dated 5/10/2005, as well as the compromise decree dated 13/9/2005, by way of a petition number 2562/2005. The second application is an application which have been registered as petition number 360 of 2022, which is a petition filed by the decree holder for execution of the for carrying out the execution with the help of the police force, in as much as the said decree could not be executed as per the court's order. By the impugned order, the petition number 360 of 2022 filed by the decree holder was allowed, and thereby directing the civil nazir to do the needful to execute the decree dated 13/9/2005. However, as regards the petition number 361 of 2022, the learned executing court had rejected it on the ground that the said application is nothing but an afterthought, that too after a period of 12 years from the date the execution proceedings have been initiated. And for the first time, the allegation of fraud have been leveled. Did you adduce evidence? Did you adduce evidence?
Sir, on the first day, my
Very well.
on the first day, I didn't get that opportunity.
So they have filed an objection 870 against the petition.
Why did you remember to do this after 12 years? The fraud?
Because of their deed, because after execution, what happened in the
Taking into
Play.
account the grounds and reasons which have been assigned by the learned executing court in passing the order insofar as the petition number 361 of 2022, this court is of the opinion that no interference is required under Article 227 of the Constitution, taking in view of the fact that the application has been filed almost after 12 years from the initiation of the execution proceedings. Secondly, the said application was not maintainable before the executing court. Thirdly, the said application is nothing. Thirdly, all this while, from a perusal of the materials on record, it has been seen that the petitioners, who are the judgment debtors, have, by resorting to all means, have deprived the decree holders of the fruits of the decree, of a lawful decree. Considering the above, the instant petition is dismissed with cost of 15,000. Stay is there?
Yes,
The earlier stay order, the order dated so and so, order to silo. The order dated so and so by which this court had passed the granted a stay is vacated, and as the parties are duly represented, they are directed to appear before the learned trial court, executing court on 14/5/2024. Full stop. On that day, the judgment debtor, who is the petitioner's herein, shall deposit the amount of 15,000 for further proceedings of the suit.
much obliged.
On the day I may be allowed to raise that question.
Absolutely
Regarding
no.
Registration.
Okay, another Punahazata output at S. Sahu. Don't make all these submissions out. This is a limit. First of all, Mr. Sahu, you know you cannot file this application in an execution proceedings.
Which one?
This 151.
361.
360.
Yes, my lord. That I could, okay, Supreme Court has said.
Where? You are
Yeah,
saying about
yeah,
you are saying about the 93 judgment?
Yes, 93, thereafter 22 meters.
What does it say? It has to be there in the suit. Fraud has been committed, has to be in the suit. Not here.
Yeah, that can be taken into the original site, no problem.
Why?
Because before that very code it was site.
So what?
The very code cannot
Nala-
exercise.
Kamay bol patu.
No, sir, but
Yes, what is this? Again, huh? What are the order you are challenging?
For rejection of the prayer of the present petitioner with regard to some documents which was thought to be adduced as the additional evidence before the appellate court.
Then?
Which has been turned down by the landed appellate court pending right now at Kapru. The court of landed it at Kapru.
You filed an order 41 Rule 27 application.
There.
Where is your application?
Yes, it's the next year.
Huh?
The next year picture details.
Where? Order 41 for allowing additional evidence on the grounds of documentary identity. Now what has happened?
Thereafter, my lord, it was rejected by. Thereafter, by adducing one document, which you lordship will find at page 53. It was subsequently obtained
Okay.
from court of.
Now what has happened? Appeal is pending?
Yes.
Yes.
It's pending. They file appeal, but then appeal, title appeal is pending. So
Huh?
title appeal is pending. In appeal, they file an application matter, order 41 Rule 27 for reducing evidence matter in appeal. That was rejected. Against that, they file review under 114 matter. That also has been.
No, they filed the review so that the good sense could have prevailed upon the judge. There is a judgment of the Supreme Court which says that you cannot have disposed of the Order 41 Rule 27 application prior to disposing of the suit or appeal.
Yes.
That both the matter has to be taken up together.
Yes.
Then what is this? No, this is an application under Article 227 of the Constitution challenging the order dated 18/8/2022 passed by the learned civil judge, senior division, Kamrup at Amingaon in misc case number 171/2022 arising out of title appeal number 10/2019. This court, it has been also brought to the attention of this court that pursuant to the impugned order dated 18/8/2022 passed by the learned trial court, First Appellate Court, a review application was filed which was also rejected on 28/7/2023. This court have duly taken note of. This court have specifically inquired with the learned counsel appearing on behalf of both the parties as to what is the stage of the said title appeal. It has been brought to the attention of this court that the title appeal number 10/2019 is still pending adjudication before the First Appellate Court. Full stop. In the backdrop of the above, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Union of India versus Ibrahimuddin, reported in 2012, 8 SCC 144, wherein the Supreme Court had categorically observed that the stage of taking an application under Order 41, Rule 27 is at the time when the court takes up the said appeal for final disposal. Full stop. Taking into account that the said application under Order 41, Rule 27 has been rejected even prior to the appeal being taken up for hearing on merits, the instant order dated, the impugned order dated 18/8/2022 suffers from jurisdictional error, and consequently the said impugned order dated 18/8/2022 passed in misc case number 171/2022 and set aside and quashed. The consequential effect of the said setting aside of the impugned order is that the order dated 28/7/2023 and passed in misc case number 228/2022 also becomes redundant. Full stop. This court accordingly directs the learned trial court, a first appellate court, that is the court of the civil judge senior division, Kamrup at Amingaon, to take up the application under Order 41, Rule 27 at the time of final disposal of the appeal. Full stop. This court further observed that the learned first appellate court shall decide the said application along with the appeal without being influenced by the impugned orders dated 18/8/2022 and 28/7/2023. Further to that, this court vacates the order dated 6/12/2023 passed by this court in the present proceedings, and taking into account that both the parties are represented, they are directed to appear before the learned first appellate court on 14/5/2024, so that the first appellate court can further proceed with the adjudication of the appeal in accordance with law.
All right.
Yes, Mr.
My
Maria.
lord, small issue. My lord, 281, my lord, Succession Act, my lord, the effect has been given mandatory, which is otherwise directly in nature.
Which
On
one?
that count, my probate application has been rejected. Lord, to impugned order page 37.
Page?
37, man.
What has happened? Means case is filed under Order 7 Rule 11.
My lord, we have filed
Rebate
rejected.
so-and-so for remand the
probate
probate
application.
here. What is this?
My lord, we have filed a probate application in absence of, my lord, one verified attested witness. Now, means, my lord, we could not procure, therefore, we have filed straightway the probate application. Now, afterward, they filed an application on the Order 7/11 rejection of claim. Now, based on that, my lord, by giving effect to Section 281, Succession Act, my lord, the impression created by the learned trial court is that.
What is this misprobate? Isn't it an appeal lies against that?
My lord,
Doesn't an appeal lie against
lord,
that order?
the appeal doesn't lie because, my lord, kindly see that the situation that has been dealt with, my lord. It is
I'm not asking whether an appeal lies against that order or not. When a probate proceeding is dismissed, you sought for an application for probate.
Yes.
So that is taken as a suit.
Yes.
Therefore, an Order 7 Rule 11 application has been filed.
Fine.
Your probate application has been rejected.
Fine.
For whatever reasons, rightly or reason. Against that, if a probate application is given, filed, even judgment is passed out there, would it be a decree?
My lord,
Whether it is appealable as per the Succession Act?
my lord, it is appealable, but question is that, my lord, if suppose jurisdiction error is there, my lord, the effect has not been given there to us. 281, kindly see, for my lord, when it is procurable, the word is very much clear. That has totally been overlooked, man.
When?
My lord,
What is the ground on which it was done?
my lord, the ground is given there to is that, my lord, 281 demands that there must be one attesting witness. But if we read, my lord, 281, the language is so,
Mr. Samaya, attesting witness for what?
my lord, for the purpose of filing application, my lord.
Understood. So file another one.
My
Or
lord,
he is dead.
we don't have, my lord, because the person which we would like to approach now, he, my lord, become hostile a little bit. Therefore, now we have to collect the evidence from other side. My lord, 281,
Now, Lordship, know that the party is now getting changed, my Lordship. This now the.
And what is the stay?
So let's say that because of the
What
or-
stay is there?
that order.
How
which-
can the impugn order be stayed? Tell
my
me.
Lord, that if you order- Anyway, my Lord, 281, my
We'll
Lord.
do one thing, Mr. Samaria. This is a matter which requires deeper consideration.
Not my Lord.
We will admit this matter and hear it sometime in 2034.
My Lord. I think
Unnecessary. What is there? And you got to stay also happy. Happy to stay at dismissal.
my Lord, that is not it. No, Lordship, only little effect to 81, my Lord, when procure. What is that? It is directly in nature, my Lord. That impression, my Lord, clearly.
Understood. But the main problem arises is that you need to either file an appeal.
Lordship may give us liberty.
I think better off you can help it. An appeal lies against this.
My Lord.
When an application is rejected or dismissed, what happens? Appeal lies
Appellate,
under section
41.
of
The CPC, but that effect here given there to my Lord. The CPC,
No.
Succession Act, my Lord.
41 of what? Of the Indian Succession Act.
No, my Lord. Indian succession about appellate provision, my Lord. That is now.
This is under Hindu Succession Act. This probate is done under what?
384 appeal. 384.
Ah, that is what? Indian Succession Act.
Yes.
I'm an appeal like.
Yes.
Okay. The learned counsel, Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner submits that taking into account the order which have been passed, impugn order which have been passed by which the entire probate proceedings have been rejected in terms with the provisions of Order 7 Rule 11 of the Code of Civil Procedure 1908. An appeal lies under Section 384 of the Indian Succession Act 1925.
Yes.
Also, taking into account, the learned counsel therefore submitted that he may be permitted to withdraw the instant application and be given a liberty to file an appeal. Also, he further submitted that during the period during which the instant proceedings have been pending be excluded while computing the period of limitation. Further to that, he also submitted that a certified copy of the impugn order also may be permitted to be taken from the registry by filing an application. Taking into account the above, the instant application stands with dismissed on withdrawal. This court, however, is of the opinion that taking into account that an appeal lies, the dismissal of the instant application shall not prejudice the petitioner to file an appeal. In addition to that, this court is of the opinion that taking into account that on basis of legal advice, the petitioner have been pursuing the instant proceedings bona fidely and diligently, the benefit of Section 14 of the Limitation Act 1963 duly applies, and as such, the period from 6/12/2023 till date be excluded while computing the period of limitation. In addition to that, this court further observes that in the circumstance the petitioner, the counsel for the petitioner files an application before the registry for seeking the certified copy of the order passed of the impugned order, the registry shall provide the said certified copy within 5 days of filing such application. Interim orders, if anything. Yes, Mr. KKT.
I am the defendant. The decree was put into execution.
Ah.
The control gave a report that the land is not value with the party.
Then,
My lord, on considering the control report, my lord, the execution proceeding was dismissed. Then they approached before your lordship, my lord. Then your lordship passed the order. It is there, my lord.
where?
It is at page 45.
Let's
Page
take a look at that.
47, your lord.
What did I say?
Page 47.
Copy of the joint agreement of the hearing to the effect that they have
The operative
objected
part-
they have first identified the decretal land before issuing the site. Then
Then my lord, the lordship pass this order, then directing them that they file a petition for review. And my lord,
where review? I didn't
my lord,
file
page
a
47,
review.
my lord, page 47,
47,
47.
not order 47.
Not order.
Yeah, 47. Yeah. 47, one people, yes, they're executing court can
Page
do.
47, your lordship. Your lordship order is at page 47.
But did I ask 47? And
Yes,
second round,
after dismissal of the execution proceeding. Your lordship order is at page 47.
yes, then
Then my lord, instead of filing this review application, they filed misc case number 59 of 2022 for uh, for cross-examination of the Amin Commission.
that's
Well,
okay.
the
Then
Amin Commission was never appointed by, and when this
no, who submitted the report? Has anybody submitted a report?
it's submitted report by the Mondol to the ASO, Section Settlement of.
Understood. That report must have come to the court.
Yes.
Some report has come.
Yes.
Whose report? Somebody has submitted a report before the court
Well.
on the basis of which the execution is to go on.
Well.
Whose report? The Mondol. Mondol or that Amin Commission, whoever it is.
I'm not Amin Commission, Mondol.
I'm a bit surprised why the executing court have not appointed a person who was appointed as per the direction for the purpose of giving a report. Who was directed?
Your lordship,
I never
that is
directed anybody. Only I asked them, then they can very well approach the authority, the court, for the purpose of in terms of Pratibha Singh. Pratibha Singh permits that the executing court in terms of 47 can very well do. Accordingly, they must have done so. Now, who was appointed by the trial court, executing court, for appointment of a commissioner? Who?
That is that I don't have matter, but Mondol has given a report.
Mondol's report is Mondol cannot be the person concerned. The court would have definitely ask either the revenue circle officer or ASO to submit the report. Who was directed? We do one thing.
The decree holder.
We adjourn this after some time. Get your instructions on that. Please the matter after.
P2, my lord.
Okay. Please the matter on 3rd of June 2024. In time order past earlier shall continue.
May.
No, June. May too many matters. I will be sitting. June is somebody else's. 3rd of June. So the draft substantial question is permitted to file additional substantial question of any and is permitted to file so this when do you want
After
this court fixes the matter after you?
okay, correction. Draft one word.
Anyways, this word does not make any sense. Do you want to do it or not? That is
My
the
lord,
question.
I am ready.
And do it if
My
you are ready.
Lord,
Anyway, this substantial question of law, I would not go by this. Can you tell me,
my lord,
what is your point in both?
suit filed by plaintiff, I am plaintiff. Suit filed by plaintiff for declaration of right title interest over Schedule 1 land and recovery of possession of Schedule 2 land. Schedule 1 land is within Schedule 2 land is within the Schedule 1 land.
So a part of the Schedule 1 land, you are asking for recovery of.
That suit was dictated. In Appellate court, reversed the judgment that aspect that no recovery shall be made.
Although right title and interest,
Yes, in favor of it.
how is it possible? Why? Let's see the first appellate court. What is the reason?
First, and I wrote the trial court, the
No, what is the first appellate court?
first appellate, yes. Page, cooperative part is page 115. But can it to 118, paragraph 30. Thus, I am considered opinion that on basis of document adduced by either of the parties, plaintiff could prove the ownership of the part of the suit land by Ramlosan Rovidas, but they failed to prove the ownership of Ramlal Rovidas, alias Ram Lagan Rovidas, over other part. Perusal of Exhibit 6, though which the plaintiff claims her title shows that her heirs of Ramlosan Rovidas, that is the pro forma defendant number 5 to 8, had sold the land measuring 1 biga. I am claiming this land, 1 biga, 8 kata, 4 kata, under second RS Patta number 181, tag number so and so, and the legal heirs of Ramlal Rovidas and Ramlosan Ramlagan Rovidas. The pro forma defendant number 913 had sold land measuring 5 kata, 6 kata, under so and so. Thus, when the pro forma defendant number 9 to 13 as thus and held above are found to be not an legal heirs of Ramlal Rovidas, sale in respect of their share being without title is not valid, and plaintiff could not get a valid title in respect of the state portion of the land. No vendor can pass a title more than what.
Where is the claim?
Plaintiff at page, translated copy at page, start from page 8.
Huh?
Page 8. At page
Eight?
page 8.
Then
Well, so far with the exhibit 6 is concerned,
Hmm.
there was no counter, no challenge that
understood, but
yes,
schedule one encompasses both lands,
both them.
but identifiable lands.
Ident-
One is 5 kathas, 6 shatats, and the other is some 1 biga,
One big, Sidul kindly see.
1 biga, 8 katha, 6 shatats. The total land is 1 biga, 13 katha, 10 shatak.
Yeah.
And of which schedule 2 categorically mentions only about the 5 katha, 6 shataks where you could not prove.
No, that I have proved.
No, that is what has
That
been
is,
held.
that finding is wrong finding, my lord.
No,
Kindly
kindly
see.
see, the 9 to 13 transferred to you 5 katha, 6 shataks.
That was transferred. Entire land was transferred at page 86. Kindly see. Trial court does. And there was no pleading that the Ramlosan Rovidas and Ramlosan Rovidas are not same and one. Page 86, whether plaintiff has right title interest over schedule 1 land, whether plaintiff is entitled for recovery of cash position in respect of schedule 2 land of
No, therefore, the question of law which you are submitting cannot be the question of law. That you have been decreed the suit for the entire land. No, that is not the decree. The decree is only respected to not schedule 1, only 1 katha so and
1 bigger.
1 biga something. And did not give the decree as regards 1 also for 5 katha 6 shataks.
Yeah.
It may be a question of perversity.
Purpose.
It may be a question, but not that the question of law which you are submitting.
It is a question of perversity because
Why you are submitting that it is perversity?
perversity is this land is with respect to this portion of land, the pro forma defendant number 5 to 13 were sold, and their legal heirs are the pattadas. of the with respect to that land. But the learned God of the court held that this land, this name is who has added dependent proforma dependent number 14 to 18. They are legally also the owner of that with respect to that land. But there is no materials on record that they were the owners of that land.
So it was by one deed of sale this transfer had happened.
Yes.
And the court bifurcated that
Bifurcated.
or apportioned only this amount.
Yes, only with respect to
So let's see what is your substantial question. Where?
it.
Now, Exhibit 6 was one document by which the proforma dependent number 5 to 13 transferred.
Transferred the land to the
So the court apportioned this portion.
Yes.
That these persons,
this portion.
9 to 13 did not have title.
Yes.
And as such, second
So-
portion,
Second portion.
and as such arrived
I
at
know
the
that is for
Schedule 2 land was not sold.
Yes.
Whereas that boundary of Exhibit 6 was a compact plot of.
Compact, not only compact, the deed was the same deed on this.
Understood. So it was a
one-
compact plot.
Yes.
Mr. S.K. Ghosh, the learned counsel, speaking on behalf of the Indian appeal. Right, the appeal has been filed under Section 100 of the Code of Civil Procedure 1908. Challenging the judgment that dated 31/5/2023 passed by the learned civil judge Elagan in slightly appeal to part of the 20. This court, upon hearing the learned counsel appearing on behalf of the petition, appellant, formulates the following substantial question of law: whether the learned first appellate court were justified in arriving at the conclusion that the performer defended whether that the Schedule 2 land was not conveyed to the plaintiff. Performer defend number 40, whether the learned first appellate court were justified in coming to a conclusion that the Schedule 2 land was not conveyed by the performer defendant numbers 9 to 13. Although by Exhibit 6, although the Exhibit 6 was a deed of sale which sold by which 1 bigha
Artist cutter.
13 katha 10 shataks were transferred by the performer defendant number 5 to 13 with definite boundaries. You should note it by step be taken for the respondents by way of registered post with AD. Report to लिखित न appeal is admitted. Court letter this court appeal is steps be taken by way of registered post as well as the LCR be called for. It's the matter of the completion of service.
That part.
What is it? Not necessary. It is useless. Yes, what is it?
Wait, Your Lordship.
Who are you?
Yeah, Your Lordship, on behalf of TK Roy,
Who are you?
respondent.
Respondent, you are in KVS?
No,
The file KVS? Then what is there? Next. What is the substantial question of law?
Lord, that page 12 and 13.
What is your point?
My lord, this book was filed in respect of 16 acres of land,
Hmm.
uh, which was illegally occupied by the defendant.
Hmm.
Now,
You are the plaintiff.
I am the plaintiff. And my lord, amongst many other contentions, one of our contentions was that these defendants, they have constructed a mobile tower in a small portion of the fruit land. Now, during trial, your order, a surveyor was appointed to determine whether the mobile tower was situated on a fruit land or not. But he gave a report that it's not situated on fruit land, but in some other portion of the land, in a different land. Now, our entire suit was dismissed, Your Honor,
Who?
which comprised
By the trial
comprised-
court.
by the trial court and even by the appellate court
Concurrent.
on the basis of this survey commissioner's report, which was only in respect of a small portion of land where the tower was situated. But there were other contentions that the defendants were occupying the entire 16 acres of land by constructing house.
Let's see the
And the-
first step.
Well, it is at page 17. Your Honor, the relevant question at page 33. You know, after discussing the report of the commissioner at point number Q, it is held that since it is proved that the tower in question is not situated over the truth land, but on a different dag and patta, this court is of the view that there is no cause of action for the truth, and as such, the issue number 1 is decided in negative and in favor of the response. The other, there were evidences, my lord, which says that the defendants, they were residing in the truth land, but those were not considered.
Let's see the plane.
Plain, my lord, it is at page 57, my lord.
This is the cause of action. I hope. Heard Mr. J. Mehdi, the learned counsel appearing on behalf of Appellate. It's an appeal.
Yes.
Under section 100 of the Code of Civil Procedure, 1958. Challenging the judgment and decree dated 11/8/2002, passed in cycle appeal number 06 of 2018. The appeal is admitted by formulating the following substantial questions of law. Whether the court below were justified in dismissing the suit filed by the plaintiff when the defendants duly admitted that the plaintiff had ownership over the Schedule Core land. Number two, whether the learned First Appellate Court by the interim judgment and decree, whether the judgment passed by the learned First Appellate Court is in consonance with the provisions of Order 41, Rule 31 of the Code, making it returnable by issue notice upon the respondent steps be taken by way of registered as well as usual. Full stop. All for the LCR. It's the matter. The receipt of the LCR service is complete.
Hello.
Steps be taken within steps. Madam, this is a stepmotherly treatment being given to petitions, taking into account I am taking bench one. Anyway.
The point is, I went to the document you submitted. We have to go on the basis of the statement which the respondent to pay. The retrofitting will not be taken into account. This is a specific statement. But I find in case of others, they have taken retrofit. And these other anomalies which are there, and that is the case of respondent. All his works were retrofit, but those were taken into account. But in my case, no. And next, in respect of I'm just giving a brief thing because I'm almost out of turn here.
No, it's okay. No, other matters have already been adjourned. I mean, they don't want to do the order matter. They have all the time.
Yes. And Lord, you could look at the documents of response number 5.
No, I remember.
Yes.
They have stated in the affidavit by the Jal book saying that the petitioner's things were all these are retrofit and as such have not been taken into consideration. Now, you say that on the other hand, the respondent number 3,
yes,
things were all retrofitting.
Right.
And as such, if that be so, the same parameters should have been given.
Well, it has not been applied.
That's
So
that's the only thing remaining.
Absolutely. And in response number 5 case, I would say it's a little more disastrous because there are two identities on it. There are two identities. Response number 5 is Tazamuddin Morigaon. His registered, his identity, everything is Morigaon. Thereafter, Lord, he gives a
Calcutta.
Kolkata with Tazamuddin. Even the letter Guwahati, Tazamuddin Guwahati. And Lord, even the letter head. I mean, I cannot think that the corporation could give to a letter head with the spelling of its name wrong. It's the spelling is wrong. So that is really.
Yes, what do you say, Mr. Bora, as regards the first aspect, retrofitting? You categorically say on affidavit that the petitioner retrofitting has not been taken into consideration.
Yes, sir. That the effort may have not been taken.
Have you taken the retrofitting of others?
Since that other also retrofitting has been taken.
Huh?
There seems to be the retrofitting of others has been taken. Retrofitting of the petitioner has not been taken. Then I categorically stated.
Then?
In fact, that what if like the page number 47 of the petition, madam. Retrofitting has to be taken if every job has to be first of all, my lord. Not
Yeah.
take the page number 32, my lord. That is the evaluation criteria.
Which one?
32. Evaluation criteria. Even if you say
47.
there is a house service
Page 47.
32 one.
Page 32.
Running case first.
32. That is the petition.
32.
32 is the evaluation criteria.
Yes.
So Lord could say that documents required.
Hmm.
Average annual turnover, CA certificate, work experience and all this house service connection, completion certificate has to be. Now Lord will turn to page number 47 of the experience of the given by the petition.
Where is the completion certificate? Documents because valid registration, company register proof, so JV agreement, so tendering. Where are you saying about complete? Oh, yeah. Work experience should have experience of working as a main contractor or subcontractor or providing water, house service,
Connection.
FTS.
Documents required.
Yes.
Document required is in house service connection is the completion certificate.
Hmm.
And in page 47, petitioner has not given house service, that is completion certificate. In what will say 1 to 3rd, the 4th, 5th, and 6th.
Hmm.
So the experience is the completion certificate has not been given.
Hmm.
So all these have to be taken into tax.
Why is there star mark actual date of completion? Star mark? Why? Why there is a star mark out there?
For actual date of completion.
Hmm.
Star mark.
Why there is a star?
Yes, there is a star mark. But that I
So 3 works have been done, but others there is no completion
there is no
certificate.
completion certificate. In fact, my lord, why
Why page 47, 48 and 49?
yes,
What
my
are
lord,
the
all
same?
my lord.
Huh?
In fact, it should not in enact, my lord.
That's
Because the reason
the duplicate.
all same.
47 to 50 are
50
all
same.
duplicate, not duplicate, quadruplates. Yeah.
What-
Four
duplicates of
pages.
the-
Then
So if retrofitting has been taken for one, it had to be taken for all. And retrofitting, there is no in the elaboration criteria, there is no that retrofitting will not be taken into consideration. There is no clause that it will not be. So once retrofitting has been taken, it will be taken on board. All have to be taken.
Hmm.
So in fact, that re-evaluation has to be done, but if retrofitting has been taken. has to
then
be
how
taken
do you
for
do
all.
it now?
That now the position of the petitioner is 7. But seventh will not come into the picture because 6 person has to be only entitled to get the order.
Okay.
30,000
No, very well.
30,000
No, others is okay. But what do you do about whose retrofitting has been taken? 3.
Everyone.
others have to-
Everyone's retrofitting has been taken.
others have to-
Then how do you take care now? Taking into
Now everything has to be re-evaluated. It has to be done, my lord.
Huh?
Everything has to be re-evaluated.
Now, what do you do as regards the work which have already been done?
The work, whatever the work has been, that amount has to be given, paid to the, they will, give the bill and they will have to be reimbursed.
It's okay, but how do you take care of that? Now, remaining work, how much is left? Because you see now,
Yes.
if I give an evaluation to be done, at
30,000,
present,
how many has been actually completed?
Huh?
Actually, 30,000 totally is there.
Hmm.
Now maybe some amount is remaining. What is the remaining amount? Remaining numbers of connections.
And I'm sure there'll be more connections in future.
In future, it will be more. Future, it will be more.
So they can empanel me.
Well, that had to be by a.
but
That,
future, that will be a different contract. How can you be empaneled now for
No,
that?
No, they were all the time, they were talking, this is nothing to be affected. More works are coming. That's
More
the
works are
standard.
coming. That is the definite, my lord,
That
because
this is the empanelment which will
only
carry on
30,000 household.
Now, is this the empanelment which will happen for all time?
for all
to
the
come?
contract.
No, no, this is for the one 30,000 only.
Now,
30,000
thereafter,
household. Right. Not more than 30,000, 30,000 fixed. And
Therefore-
everybody will get only 5,000, nothing more than that 5,000. Each sick person.
no, thereafter, if you go for a fresh one, then
Fresh one.
automatically it will have to meet the sub criteria.
That will be fresh tender.
Right.
Fresh tender. Everything
Now,
will be-
therefore, if I interfere, now ask the evaluation to be done, taking into account how can that be to the town?
If it is done, my because retrofitting has been taken in retrofitting the completion. The petitioner has not given the completion certificate.
No, he has given for three. You have only considered
Three
for,
and three.
you have not considered for seven.
Seven.
You have only considered for three.
Three.
If you have considered for three, then if those three meet up, you have categorically stated the affidavit that retrofitting has not been done, but for others you have taken.
That they have to-
If that be so, then automatically you have done some illegality against the people. Then, if you have done some illegality against the people, how? What is the course of events out there, or what is the step that can be taken for remedy? That's the question. Now, whether it would be proper at this stage to interfere.
How many connections are there?
That you should have come up with this when you are specific, then it is that you have made a mistake against the petitioner.
Well, but how many connections have already been done by the sick person?
What is the difference between five and six? 6 and 7. Number? There's a number given. You gave me. Huh? 42.65. And how much he has got? So there's the
No, the recalculate.
The recalculation.
Recalculation.
no, you have given me a recalculation. No?
Recalculate.
Where is it?
Then we came up to 7.
एक
तो
दो
7
दिन क्या हुआ था? Huh? So there was a correction made. Huh?
Correction made, my lord, it will petitioner will come 41.81, and above it is SS enterprise. It is 44.26. That is a sixth position.
Where is your affidavit? There was a colored document somewhere.
I think they gave
They-
the code.
वो कागज तो
They have another document I have with my lord. That is also colored, my lord.
कागज क्यों नहीं है क्या?
You gave
There is a color.
photo किया है, photo कितना किया?
वो तो इसीलिए
Lekin there was a colored document I have.
give me a color document, a bigger page. They have somewhere lost. What to do? That day also, today I was taking Mr. Mixter's meter so many times. They have given, they got tired giving me. No, it's not there. I should have tackled. What of this? You have the color for any
Lordship, that I have the second another section, my lord.
all who
Where the
nothing
calculation is there.
these people, how it is, how the papers are missing from the. Now he can't file a second file.
So the big sheet, man.
Yeah, X and Y mark. Both the computations are given in X. Where is that? Yes, got. Yes, now original. Now why? Yes, this is as per this. Now he has been 40.82. Who is number 6? JB Huma. Your name is?
Response number 8, 42.
SS Enterprise is not there. Purbanchal is there. Purbanchal got 89.
He's the top.
Second
Bhaskar
time it will be
Borua got 69, 67.
67.91.
Nine. Then Tajuddin got 66.96. Sunrise got 57.20. KPS got 50.94. And SS Enterprise has got 44.26. Then
Oh,
petitioner has got 41.76. Now, here you have given 15. Madam, how much of your connections have not been taken?
Dr. B pay 4,300.
Ah.
He took only 1,000 and something.
Ah.
The 1,300. And even if it, suppose they want to say that without completion, if
No, without completion certificate, that can't be taken, but
Yes.
otherwise,
otherwise only 1,100 monthly is
how much not taken?
monthly is so have been taken. And with,
No, they have taken 4,231.
no, that is what we claim.
On the basis thereof, they have given 15.45 marks to you.
No, not they haven't taken 4,000. They've taken 138.
No.
Yes, doctor.
You see this? No, that is why.
We don't have to talk about the doctor.
Oh, this document. You have the color printout?
my lord.
Give it to her. Earlier they had taken only 1,330
Yes.
and therefore you were given 4.86. Now with retrofitting you are given 4,231 and thereby given 15.45. So you have been given all these things.
Right now.
Ah.
After,
Then also you are number 7. Can't help it.
no, lordship, but then lordship will look at the response number 5. Document.
Number 7.
Number 5. Response
Tajuddin.
number 5 minutes. They should. How are those documents authentic, lordship?
What my not big order.
You file an FIR.
Yes, but Jalpur should have done that, lordship. Not
Satisfactorily, my lord, fulfill the condition.
Yes.
So far, my document was start.
I cannot say them.
Now, my lord, it's not. So far, my lord, I would like one question of the report that when my lord the first committee, then committee already accepted. And now, paragraph 40. Let's keep this.
So retrofitting is gone.
So far, my lord, my comment is concerned. satisfactorily
Mr. Bhuya, this judgment is on a different line.
and
Election is on different.
document will be accepted.
It is a-
Government has not
Mr. I do one thing. Mr. This retrofitting has gone. Nothing can be done. Mr. You call Mr. Bora.
Sure.
You do one. I direct you. I'm not touching on this settlement which has been made, but giving you a direction to inquire as regards the authenticity of the document. And to and needless do whatever investigation is required.
In respect of response.
Because if there is a false document which comes out later on, then obviously you can very well take further steps. Because then nowadays, while entering into a particular agreement or contract, you have to sign the integrity pack. Isn't it? Or Jal board doesn't have integrity.
But this
get a
case shows something else. this this empty shows there's no integrity.
Integrity pact you have.
I don't have the construction, but
No,
whatever
100%. Against all contracts nowadays, you have to sign that integrity pact. If you don't sign it, in fact, at the time of submission of your application, a tender, you have to sign that. Yes, you have not done anything. So if there is any illegalities, which for this court would not like to do under 226, you go and investigate. You find out anything, then you obviously take steps. It may be a case that you may be blacklisted for future. You may terminate. You may not give him a single penny. That's your lookout. But you have to do something if it is there. Only go and investigate.
yes, because of Mongoldo and Calcutta.
Yes.
No, there is a reason
What is
why.
the
Because
one-
there are
what is the-
certain serious things which have been. Why will the person concerned will even give in their letterhead some wrong address, wrong number? So
Spelling
these
is
these
correct.
are aspects which I think better off investigate by yourself,
Sure.
by your
We'll
thing.
look into all these things.
You may take the help of whatever authority that is. But otherwise, the retrofitting thing, I think
Taken into
it
account.
has been duly taken.
That I will not go. But this lottery is something to be looked into.
Chalo. Let me dictate.
and so far my duet verified.
That is a subsequent
All
verification.
these clarifications have no meaning out here. You clarify if the issue notice.
If you sir will be hearing it.
From my
So
part,
your main person now becomes Mr. Bora. No more discord. Yeah. The instant application under Article 227 of the Constitution, or 226 of the Constitution, challenges the this is an application under Article 226 of the Constitution, challenging the undated and unsigned evaluation sheet, bracket Annexure 5, the minutes of the meeting dated Annexure 3, and minutes of the meeting, and the notification dated 5/8/2023, whereby the respondent number 3 to 8 have been chosen as the vendor. What are they?
Was
Have been chosen as
the qualified person under the six top bidders.
have been chosen as the 6 top bidders for grant of for awarding the contract of contract, inverted comma, parallel rate contract for drinking water house service connections in lots of 5,000, comma, for total of approximately 30,000 households in South Central and North Guwahati area. Comma, providing all required goods and materials, comma, install the employer supplied water meter, comma, install the pipes and accessories, comma, evacuation, excavation and road construct restoration works all complete, inverted comma close. From the record, it reveals that the respondent number 2 herein had published an invitation for bid for providing drinking water house connections. By IFP number GWSP/LB/C hash 12B1/2023-24/04 dated 7/5/2023. In respect to the work description already stated herein above. Pursuant to the said notice inviting tender, as many as (16 persons, 16 bidders participated. The tender committee in its meeting held on 18/7/2023 evaluated the bids of all the 16 participant bidders. Thereupon, after a detailed evaluation of the bids, the tender committee found bids of 12 numbers of bidders meeting the minimum requirement of the IFB. Whereas the 4 non-compliant bidders were rejected. Thereupon, in terms with para 2.2 of the IFB and more particularly para 2.2.1, the evaluation was carried out. While carrying out the said evaluation, the respondent number 3 was awarded, and the respondent numbers 3 to 8 were awarded as follows. The petitioner as well as the respondent number 3 to 8 were awarded the following marks. After the respondent number 3, yes, table 1, 82.81. Respondent number 4, there, 63.51. Respondent number 5, there, 62.27. Respondent number 6, there, 53.35. Respondent number 7, there, 45.87. Respondent number 8, there, 42.65. However, the petitioner herein was given 28.92. And in the list, the petitioner was put at serial number 10. Being agreed by the said recommendations and the subsequent awarding of the contract to the respondent numbers 3 to 8 on 5/8/2023, the petitioner approached this court by filing the instant writ petition. Amongst the various contentions which have been forwarded, it revealed that one of such contention was that while granting marks for the work experience, the marks were awarded taking into account the what is HSC? House service connections of one D. Kumar and Company, which was otherwise a disqualified bidder. When the instant writ petition was moved before this court, before this court, this court, by the detailed order dated 12/9/2023, directed that while issuing notice, that till the returnable date, the notification of the award dated 5/8/2023 insofar as the 6th rank bidder, that is the respondent number 8, shall remain suspended. It is under such circumstances, the respondent number 8 approached this court by filing an interlocutory application, which was registered and numbered at registered and numbered as INC P166/2023. Seeking vacation, modification, and alteration of the order dated 12/9/2023. Thereupon, when the matter was listed before this court directed the respondent number 1 and 2 to provide the computations of the marks in terms with para 2.2.1 as per original assessment so carried out, as well as an assessment to be, as well as the computation of marks by taking into account the highest qualified bidder, by taking into account the 8 high service connection, house service connections of the qualified bidder. In accordance to the said directions passed by this court on 28/11/2023, Mr. S. Bora, the learned standing counsel of the respondent number 1 and 2, placed before this court the computation in original as per the original assessment so carried out, and the computation as per by taking into account the HSC of the qualified bidders. The said two documents were placed on record and marked with the letter X and Y. From a perusal of the document marked with letter X, it is seen that the assessment was carried out originally on the basis of the HSC of the respondent number 4, who had provided 8218 connections. Be that as it may, in respect to the petitioner, they had taken 1,330 HSC connections, thereby rejecting the retrofitting connections. And thereby, and consequently, the petitioner was only given 4.86 marks. On account of work experience. The second document, which is marked with the letter Y, is a document by which the petitioner's entire HSC connections were taken into account. That is 4231, and the petitioner was awarded 15.45 marks as against 30 marks on account of work experience. On the basis of the second computation, which was carried out pursuant to the passing of this order, the standing of the bidders were as such. Respondent number 3, 89.46. Respondent number 4, 67.91. Respondent number 5, 66.96. Respondent number 6, 57.20. Respondent number 7, 50.94, respondent number 8, 44.26. তাৰপিছত দিব JB, then the petitioner 41.76. Therefore, from the above assessment, it would be seen that on the basis of the allegations which have been made in the writ petition, the petitioner has no legs to stand. First, be it as it may, this court, by an order dated 30/11/2023, taking into account those documents which have been kept on record and marked with the letter X and Y, vacated the earlier order dated 12/9/2023. However, while doing so, this court, a submission was made by Mrs. M. Hazarika, the learned senior counsel, appearing on behalf of the petitioner, stating inter alia that the documents that the computations clearly show that the documents on the basis of which the respondent number 3 and 5 have shown their work experience for the house service connections could not have been taken into consideration inasmuch as they were registered with certain authorities which had nothing to do with house service connections. It is under such circumstances by the same order dated 30/11/2023, this court observed that the work allotted to the respondent number 3 and 5 shall be subject to the outcome of the writ petition. In pursuance thereto, the parties have filed various pleadings before this court. Inasmuch as the respondent number 3 and 5 have shown that they had carried out house connections for which they are entitled to be considered and have been rightly considered so. On the other hand, it has been submitted by Mrs. M. Hazarika on the basis of the affidavit, senior counsel, on the basis of the affidavit filed by the petitioner, that from the documents which have been enclosed by the respondent number 5, it's the same appears to be documents wherein the authenticity and wherein the said document, wherein the authenticity of the said document are questionable. The learned senior counsel drew the attention of, yes, madam, which document you were referring to, that thing?
The Kolkata,
Yes, sir.
199.
Referring to the document.
This one. Affidavit.
At page, the document dated 10/6/2019, issued by the Kolkata Municipal Corporation. Submitted. Then the said document on the face of it not only shows that the said document is not on a letterhead of the said corporation. In fact, the spelling used therein, inverted comma, Kolkata, Kolkatta, inverted comma, is wrong. She submitted that these documents, she further submitted that all these documents also will show, all the documents submitted by the respondent number 5 would also show that while he hails from Morrigaon as per his registration, but these documents do not refer to him as Tajuddin Ahmed from Morrigaon, but rather from Guwahati. She therefore submitted that the respondent authorities have taken into consideration these documents without making necessary investigation or inquiry. And if such inquiry would have been conducted, the respondent number 4 to 5 could not at all have been, then the bid submitted by the respondent number 5 could not at all have been taken into consideration.
With the here in my heart, the party having own this setting at Guwahati and Morrigaon. There is a lot one.
What do you say about the spelling?
There, my lord, Guwahati, my lord, equal corporate.
No, Guwahati, that spelling is okay. What do you say about the Kolkata spelling?
So there, the Kolkata and
They put another double T. Yeah.
but so far my research, I filed by the petition and clarify.
That spelling.
Very good to
Proper noun, it's a proper noun.
sometime again earlier it was a Kolkata, now it is saying Kolkata. Earlier, my lord, Guwahati also saying Guwahati, now saying Guwahati. That cannot be taken.
Earlier and now also it is Kolkata.
And my lord, so far, my lord, this 10/6/2019 letter, here, my lord, on the stamp, just properly shown Kolkata. The stamp used Kolkata, and there is the logo also.
Does anybody has the entire contract record? The contracts? Anything? The invitation for the bid? Anybody has? Just show me one.
Bit of it.
Oh,
But I have taken the interest in it.
ah. On the other hand, Mr. K. Bhuya, appearing on behalf of the respondent number 5, submitted That, Mr. Bhuya, I'm not going to put that submission. It is too, it doesn't look nice even in a judgment. Yes. Submitted that those mistakes which have been mentioned by the learned senior counsel have been duly clarified in the affidavit. And as such, there is nothing which the respondent member, and as such, the question does not arise for interference with the award passed in favor of the respondent number 5.
Yeah. But if standard committee is not. Standard committee cannot actually put it up there. The standard committee has not been.
Tender committee, what does tender committee have to do? I'm not interfering with the award. I'm only on the question as to whether you are fraud or not. That is the question. That is nothing to do with the award of the tender committee. Don't worry. I've already stated out there. I'm looking into another aspect of the matter. The submissions so made by the learned senior counsel are submissions pertaining to certain facts. Well, submissions which come within the realm of disputed questions of facts. And this court would not be in a position now would not be in a position to adjudicate the same. This court, however, finds it very pertinent to take note of the information invitation for bid dated 7/5/2023, wherein it categorically mentions that there is a code of integrity prescribed for bidders specified in the Assam Public Procurement Act 2017 and the Assam Public Procurement Rules 2020. And any breach thereof has consequences, which is apparent from a perusal of clause 11.3 and other clauses. If a fraudulent document has been placed before the tender, before the authorities by any bidder, in the opinion of the court, the same would violate the integrity code of integrity prescribed in both the Assam Public Procurement Act 2017 and the Assam Public Procurement Rules 2020. Under such circumstances, as this court is not in a position to adjudicate those aspects of the matter, this court is of the opinion that the respondent number 1 and 2 is required to carry out the necessary inquiry in respect to the documents which were submitted by the respondent number 5 by giving the respondent number 5 due opportunity for the same. This court leaves it to the best wisdom of the respondent number 1 and 2 to take necessary steps in terms with the code of integrity. With the above the instant proceedings. My lord. Well, at last, bench 5-1 more finished.
Well, I have the satisfaction, Lordship. I was being unfairly dead.
Huh?
I was being unfairly dead.
No, it is there. You got
I
47.
was unfairly dealt with by the authority.
No, you are retrospect earlier. Yes.
I was unfair. Had
Uh,
I not come, at least maybe next time they'll be careful.
Earlier you were.
I-
But after the correction, they have taken that amount.
But Lordship, the documents, they have not utilized the documents.
I've asked them.
I hope they do, Lordship.
No. But any urgent matter, something? No, it is not taking up order matters.